Hoffman presiding. As always, there'll be no talking. While His Honor is on the bench, you may be seated.
All right, good morning.
Good morning, Your Honor.
All right, what are we taking up first?
Your Honor, good morning. The parties conferred last night and again this morning regarding the substance of Dr. Shufflebarger's anticipated opinion testimony. She's the administrating expert on the behalf of the plaintiff, and we, as Ms. Douglas pointed out earlier, tried to reach agreements as it relates to sort of the scope of her testimony akin to the scope of defense counsel's experts' testimony that may be opining on the same topic areas. Here's where we are. We have specifically highlighted for defense counsel within the expert disclosure of Dr. Shufflebarger, which I have and I can provide to you if it's helpful in a highlighted form, or if you have your own copy, I can point you to those portions.
I just want to make sure I've got page 3 and 4 of your expert designation.
And that is exactly where we're focused.
Okay.
And would Your Honor like me to point out what we're talking about? So on page 3, essentially the third paragraph down, there's a sentence that begins with, "It is a fundamental expectation." It's the third sentence down. So we intend to elicit the testimony of Dr. Shufflebarger related to that opinion all the way to where the sentence ends with the word enforcement.
So is that on her? Is that your designation or her opinion that you're talking about?
It is her written letter opinion.
Okay, so are we under opinions, paragraph 4 of her opinion?
We are, yeah, so if you, on subheading 4, if
Okay.
that's what you're looking at, then there's a subheading summary.
Yes.
If we flip to the next page,
Okay.
there is a paragraph, 2 or 3 paragraphs down, it's kind of in between. It starts with, "It is even more concerning." There's a paragraph there at the top that starts with that language.
Yes, okay.
And then the very next sentence starts with the language, "It is a fundamental expectation." So beginning with that line, "It is a fundamental expectation," through the end of that sentence, which ends with the word enforcement. That is an area of opinion testimony that we intend to elicit. And then there is the last sentence, second to last sentence within that very same paragraph, which starts with, "She should have conducted." And then that sentence ends with, "at that time."
All right.
Now, the next sentence is effectively part of the agreement reached with counsel, so I'd like to elicit or explain that, Your Honor. There was discussion in pretrial motions about the issue of causation, and we alerted the court in the event that defense counsel intended or anticipated making any type of motion to strike or motion that we had not met a burden because we didn't elicit expert testimony on the issue of causation. That is why we had preemptively designated those opinions in the event that the court or the parties deemed it appropriate or necessary. We've now conferred and the parties agree that this case will not have a motion to strike or a deficiency motion on the grounds that an expert didn't opine on the issue of causation. And as a result of that, neither Dr. Shufflebarger nor the experts who may be proffered by defendants will be opining on the issue of causation or proximate causation.
All right.
So then we get into the paragraph, 2 paragraphs down. The paragraph starts with the heading or the title "at 140," but the sentence that I'm going to call the court's attention to is halfway through. It starts with the words, "It is inconceivable that a school administrator whose primary responsibility," and then it goes on from there and ends with,
Is that which sentence is that?
Sure. "It is inconceivable that a school administrator whose primary responsibility is to ensure a safe and secure environment would," after being informed, and then it continues and ends with the word "parent."
All right.
Then when we get into the area, the subheading conclusions at the bottom, Your Honor, essentially the top, really everything until period, everything on that paragraph, the portion that we don't intend to elicit, but that we'd like to alert the court of is that there's a section that there at the bottom that says would be expected to take immediate decisive action to safeguard students, staff, and the broader school community. And Your Honor, I'll put again on the record that we do believe that there is a special relationship duty that's been triggered by the facts that are before the court, and we do intend to make a motion later on as it relates to that, and that is because of the class of persons that Dr. Parker as a public official had responsibility to. And so our intention as it relates to her testimony on that regard, in light of Your Honor's previous rulings, is to effectively ask her about the safeguarding, but not ask her to specifically identify who she's safeguarding in that context, if that makes sense to the court.
Okay. All right, so are these agreed upon things she can testify to, or do I need to make a ruling on those 4 things?
Those are
Yeah, I think
that
they
last.
need to be heard on.
Okay.
Well, let me finish and then they can be heard. Then there's the last sentence, Dr. Parker's failure to act on the critical information presents, and then it goes on that last page into the word duty of care. There were discussions amongst counsel about using the term gross negligence because it appeared in some of the actual designations. Parties have agreed that we won't be eliciting, and we're going to inform our experts not to use that legal term, gross negligence, but that we recognize that there may be what we've been calling buzzwords that are contained within the jury instructions in terms of what amounts to gross negligence, whether it shocks a conscience, whether it's indifferent, that may come up during the course of the testimony, and that's sort of good for the goose, good for the gander.
All right. I guess we can take those up as they come.
Yes, Judge. Thank you, Your Honor.
All right.
Morning, Your Honor.
Good morning.
Judge, I'd like to address a few of the issues that were raised by opposing counsel, and then Ms. Douglas can supplement. She may have additional argument that she'd like to raise that's more specific and tailored to these arguments. But at the threshold, I want to note that with respect to Dr. Shufflebarger's anticipated testimony, the defense would stand on its prior objections based on the motions in limine that her testimony is predicated on the false assumption that the underlying handbooks and internal private protocols implemented by Ridge Neck Elementary School do not establish the standard of care and do not establish the existence of a legal duty. And moreover, it would fail for Rule 403 balancing because first of all, it would have no probative value in this case, and any probative value would be vastly and substantially outweighed by the risk of unfair prejudice and misleading or confusing the jury about the appropriate issues in this case. I stand on those prior objections, Judge. But that being said, to the extent that her testimony may come in, Judge, I would ask that the court issue a proper limiting instruction at the appropriate time so that we can mitigate the risk of the jury reading these instructions, hearing Dr. Shufflebarger's testimony, and conflating those principles by thinking that because there is a handbook that has these directives included in it, these are private rules, they don't establish the standard of care or the existence of a legal duty. So I stand on our prior objections. I incorporate them here expressly by reference. But nevertheless, to the extent that this evidence may come in, I'd ask for a proper limiting instruction. 2 other points, Judge. I heard from opposing counsel mention...
Let me catch up with you. Hold
Yes,
on
Judge.
1 second. All right, so for reference, defense filed its first motion in lim back on October the 2nd of 2025, and inside that motion in lim, there were designated a number of motions in lim. We are specifically referring to motion in lim number 3 as filed in that document that lists 2 objections that Dr. Shufflebarger's testimony improperly implies Newport News' internal policies and procedures. We'll call those internal policies and procedures objections. All right, and then there is Roman numeral 2, unfounded factual assumptions. All right, and so you are obviously, those are continuing, correct?
Yes,
that I
Your Honor,
need to
that's correct.
rule on. All right. And then you're saying that assuming that I do overrule you on those 2 points, then you are going to proceed with another argument. Is that correct?
Yes, I would specifically just ask the court to issue or allow us to issue a proper limiting instruction, as we have done with the other similar rulings with respect to the handbook and internal policies generally.
All right, and what is your framework for that? I mean, what are you planning on offering for that?
I think at this stage, this is something that I would like to coordinate with opposing counsel at the appropriate time. We have not discussed the specifics, but I imagine a cautionary instruction would be something to the effect of, ladies and gentlemen of the jury, you've heard evidence of internal policies and procedures implemented by Rich Neck that were in place at the time of the incident. Under Virginia law, these do not establish the existence of a legal duty. These do not establish the governing standard of care in this case. Nevertheless, you may consider it for another purpose, and there are some specific purposes that are authorized in the case law, and we can hash that out with opposing counsel.
All
But
right,
at this
so-
time, we have not worked that out.
So if I understand your argument, you are concerned, and this would be Roman numeral 1, that a jury may misunderstand that the internal policies and procedures are the standard of care, correct?
That's correct.
But you don't disagree that they are a factor in determining what the standard of care is. You just don't want it to be the standard of care.
I would argue that, in essence, Judge, that's correct. But also, I would re-emphasize that if this is coming from an expert, and given her credentials, it would bolster and enhance the credibility and weight of that testimony, and so it increases the risk of this misleading the jury and then giving them undue weight and further reinforcing the improper conflation of issues.
Okay. All right. So then basically you're asking me to rule on your first 2 objections, or your 2 objections listed in the motion in lim as filed, and then if those objections are overruled, we will take up a limiting instruction at the end of the trial.
That's correct, Judge.
Okay. All right. Just want to make sure we're all talking about the same things.
Yes, Your Honor. Thank you.
Okay.
The other point which was drawn to my attention just now was I heard opposing counsel assert that they believed that there was a special relationship duty that arose. And perhaps that was a misstatement, I'm not sure. But there were 4 claims that were part of the original lawsuit in this, Judge. The court had dismissed the count arguing a special relationship theory. So to the extent that counsel is relying on any legal duty that would arise from the evidence here, that the evidence that the jury can rely on to render a verdict in this case, I would argue that is improper. The court has already addressed that, has dismissed that alternative legal theory. This would be improper at this stage to raise it. And so, and it's well established, I would stand on my prior arguments that led to that motion to dismiss on summary judgment, that there is no special relationship that applies here, either de jure or de facto, and that is what the court ruled.
All right. I will probably take that issue up again after I hear from Ms. Douglas on
Thank you,
the
Judge.
other ones. All right.
I think Mr. Hogan addressed all of mine.
Okay.
Yeah.
That was everything? Okay. All right. Very good. So I am going to overrule the motion in lim for the 2 arguments on internal policies and procedure objections and unfounded factual assumptions, and I'm going to allow her testimony and overrule those objections. However, I will grant a limiting instruction, and we will work on that language at the end, towards the end of the trials, and that will also be based on what she actually does testify to, I think. All right, so now I am going to ask that you address again the argument about eliciting testimony about a special relationship, because that issue is not going to be before the jury.
Yes, Judge. I think we recognize that the court ruled on this issue at the summary judgment phase of this case, and I think what that recognizes, at least procedurally, is that a special relationship was alleged, and it was alleged sufficiently on the pleadings, and the court, in a mixed question of law and fact at the summary judgment phase, determined that there wasn't sufficient evidence to support a determination of a special relationship at that time. Now, in a circumstance of a trial, evidence is before the court, and that evidence may or may not differ from the evidence that Your Honor deemed sufficient or insufficient at the time that Your Honor ruled on the summary judgment issue. But because evidence is before the court at this point, and essentially at some stage there will be a request of certain duty instructions that go to the jury, I wanted to alert the court that that is an issue that we intend to ask the court to reconsider at that time. And it's specifically related to the evidentiary foundation, both that's been laid thus far and what we think will continue to be laid as it relates to the facts of this case, and as it's akin to the Bernadette case, and then akin to the Burns v. Gagnon case, although the Burns v. Gagnon case decided no special relationship. In the Bernadette case, it talked about an individual in a public official in a capacity, and the discussion in that case is the courts do not impose a special relationship on a public official to the people at large, and just generally speaking to every citizen that is around, and we recognize that. And Bernadette recognized that. And the difference in Bernadette was that there was a specific individual, or as the courts say, a class of individuals with whom there was an appreciated danger or risk. And in light of that, that public official then had a special relationship, not an assumed duty of care, but a special relationship with those individuals, that class of individuals, in order to take affirmative action. And the Burns v. Gagnon case, when observing that, said explicitly, we concluded that a special relationship existed, that is, talking about the Burdette case, between the deputy sheriff and a motorist because the sheriff knew or should have known that the motorist was in great danger of serious bodily injury or death. And so one of the issues that comes up as it relates, and it continues, and this is where the court contrasts, the Burns court contrasts it with the Burdette court, and says, in this case, by contract, there is no evidence in the record suggesting that Burns knew or should have known that Gagnon was in great danger of serious bodily injury or death. What we know at this point in the proceedings, specifically from the testimony of Ms. Farish yesterday morning, and then again throughout the afternoon in the testimony of Ms. Kovac, is that there was a certain appreciated danger of a firearm on campus that posed a danger, and that danger that we're talking about a firearm, we're not talking about a circumstance in which in Burns v. Gagnon there was a potential fight, right? Two different potential dangers in that circumstance. With the firearm, we're talking about a great danger of serious bodily injury or death. That is, frankly, Judge, that's why everyone's here today. And so, in light of that, and in light of the testimony that's come out as it relates to Dr. Parker's knowledge of it, we intend at some point in this trial to propose to the court, A, to reconsider that ruling, and then B, to issue an instruction on that. And that's one of the reasons we were hesitant and objected during opening statement of opposing counsel, which is we don't know what the duties are that are going to be advised to the jury at the end of this case. And so we're not asking the court to reconsider it at this time. We recognize that the opinion testimony of Dr. Schuffelbarger isn't necessarily changed by the context of the court's ruling on that issue at this time, but we also didn't want to sit idly by and not alert the court of that intention in light of the fact that Your Honor found it relevant to the determination to make as it relates to Dr. Schuffelbarger.
So she's not going to use the phrase special relationship?
She is not.
Okay. So with that, I don't need to hear from you right now. I'm going to let you argue. And I'm not agreeing that I would permit that at all. That'll be saved for a later date. But I understand what you're doing and why, and I appreciate the heads up.
Yes, Your Honor.
So at this point in time, as long as she's not using the phrase special relationship, then I'm going to allow her testimony, and then we will take that whole issue that you just discussed up at the end after all the evidence has been in. And that's when I'll let you respond to all of that.
Your Honor, with your permission, could I address some specific arguments very briefly here? Because I think I now understand some portions of the argument, but I think will assist the court when we need to address this in more depth at the appropriate time. May I do so, Judge?
All right, briefly. I want to get going here. And once again, your objections are completely preserved to this issue.
Yes,
I'm not holding, you're not being able to respond in full again
I appreciate
in any
that,
way.
Judge. I appreciate that, Judge. I just want to clarify for the court's benefit and for opposing counsel.
No.
I want to emphasize that what this will amount to if the court allows plaintiff's counsel to pursue a special relationship theory at this juncture after having dismissed with prejudice the special relationship legal theory would be permitting them to resuscitate and revive.
Right, and I'm not allowing them to do that. Your objections are preserved.
Yes,
Absolutely.
Your Honor. But also, I would argue that this would amount to an improper, it would allow them to amend their complaint in mid-trial, which would be a due process notice violation, and this would also implicate the prior arguments by the defense on our motion in limine seeking a limitation of their theory of prosecution. This was precisely what we talked about in the pretrial conference, where there was a concern that plaintiff's counsel would try to backdoor revive dismissed claims. And I think that this is the path that they're heading on now. They are attempting to circumvent the trial court's ruling by saying, I understand, Your Honor, you dismissed this claim with prejudice, but let us pursue this alternative theory by another name. And it would be a de facto modification of the amendment of the complaint, which is completely impermissible, would deny Dr. Parker her due process rights. So I just want to put that on the court's radar, and we will address it in more depth at the appropriate time.
And your objection is contemporaneous, and I do note that for the record.
Thank you, Judge.
Okay. All right. Anything else we need to take up before we bring the doctor out?
There is, Your Honor.
Okay.
The, actually, do you want to do that first?
Sure. We just have one exhibit to enter, Your Honor. It's Exhibit 119 from yesterday, defense exhibit.
All right. And which one is that?
119,
That was a text message,
page
Your Honor.
131.
Oh, there it is. I do see it. I did admit that.
Okay, and just to get it in the record, I think we have the original copy for the record.
Okay, very good.
Also, just a note to the court that any video clips will be placed on a USB drive and given in total at the end of the case.
Correct. As and I guess are you going to save them as that item number?
Correct.
Perfect. All right. Fantastic.
So, on the topic of videos, a good segue. Last night we had sent opposing counsel clips that we intended to show during the testimony of now Detective Rulin, who was a first responder of the shooting. And those were body-worn camera footage. We've showed them to opposing counsel in order to try and streamline this once the evidence was starting to come in. They have, I think, a couple objections or a series of objections, so we thought it might be best to address those with the court before we impanel the jury and begin. The reason I say that is, for timing reasons, we'd like to call her before Dr. Scheffelbarger because she has somewhere to go.
Okay.
And so we'd like to address that now, if we could, Your Honor, and then bring the jury out.
All right. Do I need to see them?
I think you do.
Okay.
In light of the substance of them, Your Honor, we're going to ask our client to step out, and we'll probably ask her to stay out of the courtroom during the pendency of that witness's testimony, depending upon your court's ruling.
Okay.
But we wanted to alert Your Honor of that, so it wasn't as though she just wasn't here.
Okay. And are you agreeable in proceeding in that manner?
Yes, Your Honor.
Okay. Very well.
And if you don't mind, Your Honor, I'll walk her out to the room. She wanted me to show her where to go. I'll be right back.
All right. So we are going to voir dire potential objections to videos.
Yes, Your
Okay.
Honor.
Very well. Right, and we are going to assume proper foundation has been laid, and then this is what they would play, and then I'll hear objections.
Correct, Your
All
Honor.
right.
And for context, these have been stipulated as authentic as part of the stipulation.
Okay.
Go ahead. This is...
You got a smile and how many you still need around? Right here.
And it did come out her hand, either it's in her hand. We're gonna take care of her, okay? Minutes are on their way in.
Around the corner, okay?
We need to look to see, did it exit? No. How many times was she shot? How many gunshots did you hear? One.
Gunshot, okay?
Sorry, ma'am. We're gonna get up close and personal with you, okay? Please.
You're okay.
Not actively bleeding right now.
Nothing on the lower.
Okay. I'm gonna roll you over a little bit, okay? I wanna see if you're clean now. Okay. Go ahead and lift your arm a little bit. Okay. I have my mom's. Are you in pain anywhere else?
Yep.
804.
Nope. Tell me your mom's number.
Eight. Oh.
What's your name?
Abby Werner.
25.
25. Do you have a history?
That's the first clip, Your Honor. There's 3 clips.
Okay.
So I don't know if Your Honor would like to take them one at a time.
So what number has this clip, or are we giving this clip?
110A.
Plaintiff's 110A. Did you want to go clip by clip, or you want me to watch all 3 and then you can respond? You have a preference?
I think it would make sense to do one by one, Judge,
All right.
because the arguments differ.
Okay.
Judge, may it please the court. With respect to this particular video, I think there's a number of problems in why it should be rendered inadmissible. The first is that, first and foremost, under Rule 2403 of the Rules of Evidence, evidence is inadmissible even if it is relevant, if the probative value is substantially outweighed by the risk of unfair prejudice, misleading or confusing the fact finder, here the jury, or it is needlessly cumulative. This runs afoul of the needlessly cumulative prong, as well as the risk of unfair prejudice in misleading or confusing the jury. With respect to the cumulative nature of this video, Judge, you will hear in the course of this trial, and we already have fact witnesses testify that Ms. Werner suffered a gunshot injury. We've heard a medical expert come and take the stand and testify under oath in detail regarding the specifics of that injury. The jury has reviewed demonstratives depicting how she was injured, the seriousness of that injury. All this evidence has been established already. Numerous fact witnesses have also testified to the impact of that injury on Ms. Werner, as well as her family. And so we already have competent evidence before the jury on these points. This evidence would only be probative of establishing the nature of the damages, if any. And here, given the existence of competent evidence on that point already, any probative value is minimal at best. In contrast, the risk of prejudice to the accused is unfair and substantially outweighs that probative value. Because you can see, it is difficult to watch this video. It will have a strong impression on the jury. And of course, the jury is entitled to consider the evidence. They should understand and hear competent evidence that is probative of the material issues in dispute. And of course, damages are at issue. I acknowledge that. But this video is inflammatory. It is likely to incite sympathy. It is likely for the jury to render a verdict based on those improper grounds. The authority is well established. Those are improper grounds. And I also acknowledge that under Rule 2403, and the court's well familiar, the court may issue a limiting instruction to try to mitigate some of those risks. But I think that in this particular case, Judge, given that we already have competent evidence addressing these exact issues, this is so inflammatory that the jury would not be able to compartmentalize. You can't unring the bell once you see and watch this video. And given that circumstance, I think that it cannot be cured by a limiting instruction. The risk is too great, especially in this case. We will hear from other experts as well, I imagine, on medical damages and the nature of injuries. And so, again, this is cumulative. It fails Rule 2403 balancing, and it should be excluded. The final point, Judge, is to the extent that there are statements on that video attributed to Ms. Werner or anyone else, to the extent that is offered for its truth, I would object on hearsay grounds and ask that it be excluded and not considered by the jury.
All right, court overrules your objection. It's more probative than prejudicial. It's not cumulative, and it is not hearsay. Next.
110B, Your Honor.
This is Abby.
We got Robin.
Hey, so we're gonna pick you up on camera and get you on the stretcher. We're gonna go to Riverside, okay? You want to move your arm all right?
She has a bullet in her hand.
Okay. All right, well, you're doing just fine, okay?
Does she have something in her hand?
I have the shoulder, yep. 1, 2, 3, up.
Alright, I'm coming out. I'm getting the medic.
You allergic to anything? No. I need to ask you what the no other victims? No. I need a little room.
All right. I'm not sure why we split that clip up, but
I understand, Judge. There's a third video that's slightly different, but I rest and stand on my prior arguments.
okay. Yeah, and I would like that. I'm going to overrule the objection. Objection noted for the record, contemporaneous, and I would like that be one clip.
Are they different in time? That's why we split them.
There's something cut in between. There's a cut in
Correct.
between.
And the thing that was cut in between was a conversation about the minor, which
Right.
is why I cut it.
So you can't show it as well. I mean, you could just press the next clip.
I could just
correct?
press the next clip, and we could admit them as exhibits, as a single exhibit number. I don't want to mislead the jury to think that those two
Right.
things happen in the same moment, though.
All right.
And if I may, Your Honor, it'll help with the witness to be able to go through one clip, play the next clip, and then
Okay.
the third clip.
All right. I'll allow that. Contemporaneous objections. All right. And since court's ruling is the same as on Exhibit 110A. All right.
110C now, Your Honor.
Wait, we just did 110B, I thought.
C.
C now. Okay.
You okay, Abby? Everything's gonna be okay. They're gonna take really good care of you.
What's that?
Yeah, of course. Do you have any pets? Yeah, what kind of pets do you have? What's the cat's name? Yeah? How old is your kitty cat? 3. I got a dog. His name's Abby. And he's a turd right now because he won't get his ears cleaned by the vet. He like runs some ice from us. Yeah? I also got a hound that he's relaxed. Are you married? And are we dating? Yeah. Does your boyfriend live with you? Your significant other, I'm sorry, no? Kinda? Okay. I gotcha. Okay. Are you...
All right. I've seen the clip.
If I could just argue from counsel table.
You may.
With respect to this.
Speak up a little, please.
Yes, Judge. With respect to this particular clip, I stand on the prior objections based on 2403. But in addition, why I wanted to single this one out, Judge, is because this one has extensive inadmissible hearsay in it, more so than the other clips. It would be appropriate for Ms. Werner to take the stand and testify to some of the details she had here, but this cannot be backdoored. There's no applicable exception. They have the burden of establishing that. So I'd ask it be excluded.
You have a little more of an uphill battle on this one. You know, both the words and I guess the video itself. So I'll hear you.
Your Honor, the pertinent nature and the reason we selected this one in addition to the other two is first, it demonstrates a different period of time, all of which, in terms of the timing, needs to be considered by the jury in determining the adequacy of their verdict. Number two, and on to the issue of hearsay, there's a moment in the video in which Ms. Werner says, "Can you tell me a story?" And that is not a pertinent fact in this context of we need that for the truth. But what it demonstrates, even if it is offered for the truth, is what 8033 permits, which is it demonstrates her then existing state of mind, that she is trying to distract herself of the experience that she is enduring in that moment. And then all the statements and the conversations that flow from that, whether her cat's name is Jack or Jill, and whether the dog's name is true or untrue is not the substance that's important. It's the fact that in that moment, the severity of the circumstance as depicted by the video and by the conversation, which is to try and distract her from her experiences as she's going through them, demonstrates what is an element to be considered by the jury, which is her mental anguish throughout this process, that it was taxing on her to the extent that she affirmatively requested, take me away from here and tell me a story.
At this point, it's more prejudicial than probative. Now, if she testifies and it can be used for another purpose, I might allow that. So at this time, through a witness other than Ms. Werner, I'm going to sustain the objection.
Yes, sir.
However, I give you leave to try to introduce it again after or during Ms. Werner's testimony.
Yes, Your Honor.
All right. Exception noted. All right. Any other issues to take up?
No, Your Honor. With the court's permission and opposing counsel's permission, I'd like to go and inform the witness of the ruling so that she knows which two clips will be played.
All right. Any objection to that?
No, Your Honor.
Okay. All right. So we'll take hopefully a brief recess. Brief recess,
Brief
and then
recess.
you just let Deputy Hopkins know, and we'll come right out, have the jury set, and we'll start our day.
Yes, Your Honor.
Okay. Perfect. Thank you all.
Please rise.
All right.
You may be seated.
Is the jury ready?
Jury is ready.
All right. You may bring them in.
Your Honor, would you permit us to inform the jury that our client is present, just not present in the courtroom? Or would you like to do that, or would you like us to be silent on that issue?
Do you have any objection to that?
No, Your Honor.
Okay. I'll just welcome them for the morning, and I'll let you start your, when I ask you to call your, well, actually, let me say a few words to them, then I'll let you do that, then you call your next witness. Okay.
Yes, Your Honor. Thank you.
Thank you.
Good morning, sir.
Thank you. Please stand for the jurors, always. Nine jurors in the box.
Thank you. Request a poll, Mr.
No, Your Honor.
All right. Good morning, ladies and gentlemen. I just want you to know we got here the same time you did, and we had some things that we needed to take up to make the day go smoother and quicker, and most importantly, not a lot of the up and down that I've told you about I really want to avoid for you folks. So I just want you to know that. Ms. Beniozen.
Yes, Your Honor. Our first witness will be Detective Rulin. She's in the courtroom. And with Your Honor's permission, I wish to...
You may.
Our client is here. Ms. Werner's here. She's just not in the courtroom for this portion of it, just given the nature of the testimony you're about to hear. Just wanted y'all to know that.
All right. And the court has permitted that. All right. Come on up.
Your Honor, we also, if there's any other witnesses who are present, that they be excluded besides.
All right. Are there any other subpoenaed witnesses in the courtroom? All right. Thank you.
Stand right here, face the clerk.
Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do.
This way. Watch your stepping up.
May it please the court.
You may proceed.
Good morning.
Good morning.
Could you go ahead and state your full name for the court reporter, please?
My name is Detective Amber Rulin.
And Detective Rulin, what department do you work for?
I work for the Newport News Police Department.
How long have you been with Newport News?
I have been sworn since 2018.
And back in January of 2023, Were you with Newport News Police Department then?
Yes.
And what was your role then?
I was assigned as a uniform patrol officer.
And on January 6, 2023, did you respond to Rich Neck Elementary School?
I did.
If we can go to the IPVO. Oh, I do need to pull that. This is just a little roadmap, Detective Rulin, and just to tell you what we're going to be talking about. I just want to talk to you about your observations at Rich Neck, and then my understanding is that you accompanied Mrs. Werner on her route to Riverside. Is that correct?
Yes, sir.
And so we'll be talking about that as well. Okay?
Okay.
To start us off, at the time, January 6, 2023, were you wearing a body-worn camera?
I was.
And was it activated when you responded to Rich Neck Elementary School?
It was.
And if I showed you footage from that, would you recognize it?
Yes.
Okay. If we could go ahead and show clip 110A. And Your Honor, I'd move the clip 110A, which was already subject to argument, into evidence at this time.
All right, based on the court's pretrial rulings, your continuing objection, I am going to allow it.
Thank you, Your Honor.
Yes,
Permission to publish, Your Honor.
you may.
Is this your body-worn camera?
It is.
And do you recall this day now, having seen it?
Yes.
And I understand this may be difficult, and we're going to walk through the next part slowly, okay?
Okay.
All right, go ahead, Reed.
Nothing on the other side.
And it didn't come out her hand either. Just her hand. We're gonna take care of her, okay? Our minutes are on their way in.
Around the corner, okay?
We need to look to see, did it exit? No. How many times was she shot? How many gunshots did you hear? One.
Gunshot, okay?
Sorry, ma'am, we're gonna get up close and personal with you, okay? Please.
You're okay.
So I'm actively bleeding right now.
Nothing on the lower.
Okay. I'm gonna roll you over a little bit, okay? I wanna see if you're clean out. Okay. Go ahead and lift your arm a little bit. Okay. I have my mom's. Are you in pain anywhere else?
Yep.
804.
Tell me your mom's number.
Eight.
What's your name?
Abby Werner.
25.
25. Do you have a history of
Detective Rulin, that last statement from Ms. Werner was her age. And were you able to hear it when you were on scene?
Yes.
And you can hear it on the camera or the body camera that it's soft or faint. What do you recall about that, or what did that indicate to you?
Can you rephrase the question, please?
Yes. When she expressed her age at 25 years old and it was faint, did that tell you anything in terms of your observations and what you were doing to take care of Ms. Werner about her potential injuries?
So I'm not a medical professional, so I'm unable to advise you if that meant anything for her medically. I did observe the injury to her chest, and there was the cloth covering the injury to her hand. I did not observe an exit wound, which is what I was checking for prior to the medics arriving.
And is that why you had rolled her over at one?
Yes.
Understood. Thank you. Soon hereafter, the medics did arrive, is that correct?
Yes.
And then when the medics arrived, you all took additional steps and actions at that time?
She was loaded onto the stretcher by the medics, and she was put into an ambulance where she was transported to Riverside Regional Medical Hospital.
Okay. I'm going to show you what's been marked as Exhibit 110B. And, Your Honor, I'd now move that into evidence.
All right, previous objections noted for the record. and contemporaneous. All right, you may proceed.
110B.
This is how I feel.
Hey, so they'll pick you up on camera and get you on the stretcher? Move your arm, all right?
She has a bullet in her hand.
Okay. All right, well, you're doing just fine, okay?
Does she have something in her hand?
I have the shoulder, yep. Once you pick up.
Ow.
There you go.
All right, I'm coming out. I'm getting the knife.
You allergic to anything? No? I need to ask for some now.
Detective Rulon, we just observed the loading that you just discussed. Can you walk us through what happens from this point in time once she's loaded on the, tell me the correct name for it.
It's either an ambulance or, as we call it, a medic. She was put into the medic by the medics and staff, and then I, as a law enforcement officer, got into the back of the medic and rode with her to Riverside Regional, where I remained with her until I was released.
And when you say released, you walked her into Riverside.
I walked with her in her stretcher to the trauma bay and to the subsequent room that she was put into. So wherever she went, I went.
And during the medic ride or the ambulance ride, did you observe her being provided treatment by the medics?
Yes.
And what, if anything, do you recall during those moments?
I don't recall exactly what they provided her medically.
I understand. Thank you very much for your time. Those are all the questions I have.
All right. Any cross-examination?
Nothing for defense, Judge. Thank you.
All right. May she be released?
She may be.
All right. Not subject to recall?
Not from us.
From defense? All right. You are excused and you will not be called back. Please do not discuss, because this is an ongoing case, your testimony with anyone, but you are excused.
Thank you, Your
All
Honor.
right. Thank you. All right. Next witness.
Your Honor, our next witness is Deputy Thomas Blythe, and he's in the back.
Okay.
With the court's permission.
Let me get you to stand here, face the clerk, raise your right hand.
Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. This way.
This way.
Watch your step, step it up.
Good morning, sir.
Good morning.
Could you go ahead and state your full name for the court reporter?
Thomas Arthur Blythe.
And Mr. Blythe is a Corporal Blythe?
Retired, yes.
And retired from what department?
Newport News Sheriff's Office.
And were you active in January of 2023?
I was.
And on January 6, 2023, did you respond to Rich Neck Elementary School?
I did.
And I'm going to ask you about your observations from Rich Neck Elementary School, and that'll be, if we can go read to the IPVO, it's just a little roadmap. That's all we're going to talk about, is your day at Rich Neck Elementary. Okay?
Okay.
So can we start by, do you recall how you first heard of a call for a response? And I don't need to know what was said, just how you first heard of the call to respond to Rich Neck Elementary.
Came over the radio.
And where were you in time and space in relation to Rich Neck when you received that call?
I was about a 5 to 6 minute drive, maybe, with lights and siren going.
And when you arrived at Rich Neck Elementary, were you first, second, third in terms of first responders on scene? What were your observations?
I was technically first. Deputy Briggs was maybe 20, 30 seconds behind me.
And when you first arrived at Rich Neck, talk us through what you did in that moment.
We immediately went to the front door of the school, hit the buzzer, knocked on the doors, couldn't get in. Didn't see anybody moving around. Not what we expected to be responding to a situation like this. It seemed like an eternity for us was probably about a minute of banging on the door till I think a janitor or a security person opened the door for us.
And if we could go to Exhibit 9A, and don't publish that to the jury quite yet, just to the witness in the court. Publish it to the witness in the court, please, Reed. Do you see, if we can pause it, do you see that image up on the screen?
Yes.
And is that an image of you as well as other uniform officers?
That's Deputy Briggs, first one through the door, and I'm right behind him.
You're going to move Exhibit 9A into evidence.
Any objection?
No objection, Judge.
So admitted.
Permission to publish.
You may.
If we could start it from the beginning, Reed. So is that the moment that you were discussing? Janitor had let you all in?
Mm-hmm.
And that's you there at the left and two Newport News Police Department officers as well, is that
Yes.
correct? And when you walked into Rich Neck Elementary, were you being provided guidance from anybody on where to go? In other words, how did you know? where
We
to
just
respond?
headed down the hallway. We naturally gravitated towards the office. I think there were some people in the doorway. We stopped briefly, looked into the office, saw there was a woman on the floor. Some people were attending to her. And then myself and at least the other two police officers, and I think Deputy Briggs was with us, headed down the hallway because we were trying to find out where the person with the gun was.
And have you now come to know that you were walking into room 11 or classroom 11?
Yes.
If we could show to the witness Exhibit 3, what we'll call 3A, which is Werner 6707. Just to counsel, please. Thank you, Reed. Do you recognize that photo in front of you?
That appears to be the classroom.
We'd move 3A into evidence, Your Honor.
Any objection?
No objection.
And it's just a photo, not a video, correct?
Just a photo.
All right, admitted.
Permission to publish.
You may.
Go ahead, Reed. And Corporal, can you walk us through what happened as you walked through this door, room 11?
As we stepped through the door,
Can I give you a little bit of, not legal advice, but a little bit of legal advice? Refrain from saying what you heard people say, but really just your observations, if that's okay.
stepped through the door, and there was a young child attempting to be restrained by a woman. Later found out was Amy Kovac, the reading teacher. We were quite taken aback. We didn't expect to see so young a suspect. She said that she had control of him, that the gun was in the back of the classroom and pointed that way. I immediately headed in that direction. When I found the weapon on the floor, I called out that there was a gun, and I stood by.
Can I pause you there just to bring the jury along? If I can show you Exhibit 3C, which is Werner 6726. And just to the witness and counsel.
6726.
Yes. Do you recognize this photo?
Yes.
And is this a photo of the classroom, room 11, on January 6th?
Yes.
And can you see a firearm within the photo?
It's laying on the floor next to that chair.
All right. Your Honor, I'd move Exhibit 3C into evidence.
C is what we're calling
C.
All right. Any objection? Without objection.
Permission to publish?
You may.
And we can sort of see that in the bottom left there. Is that right,
Yes.
Corporal? And there's, if you can see in the photograph, there's a checkered backpack there on the right-hand side. Do you see that?
Yes.
Did you all later, at some point in time, come to know that to be the backpack of JT?
I did not. I was not involved with the backpack in any way.
Understood. And so there are, if we can jump to Exhibit 3E, just for the witness. And when you're, as that gets up, as a responding to a crime scene, usually there are other individuals that will come after you as the first responder to take these photographs. Is that correct?
Yes.
And ultimately, these photographs, as they appeared in the firearm, as it appeared, you were sort of guarding the location of it so that it would remain in that location until those individuals arrived.
Yes.
Excuse me. 6728. If you can, it's at the bottom of the screen. You need to zoom out. All right. You recognize that as a closer shot of the firearm?
It is.
And I'm also going to show you what's been marked as 6730, which is another photograph of the firearm. And that's a closer shot of the firearm, is that correct?
That's correct.
All right, so you're on a move both what we'll call 3E and 3F, which were those last two photographs shown into evidence.
All right, any objection?
No objection.
All right, without objection, permission to publish.
Permission to publish 3F, the most recent photograph.
You can go back and show them E.
I will.
All right.
And that's sort of a ruler on the right-hand side or something to give us an idea of the size of the firearm. Is that
I believe
commonplace?
that's correct, yeah.
And then if we go back to 6728, which is the 3E, that gives us a broader vantage point of where it was within the classroom as well. Is that correct?
That's correct.
Those are all the questions I have for you, sir. Thank you.
Thank you. Any cross-examination?
Yes, Your Honor.
Yep.
Good morning, Deputy Blythe.
Morning.
Counsel's asked you about your involvement in the investigation on the day of the shooting, correct?
Correct, yeah.
And you've mentioned that when you responded to Rich Neck Elementary School, you encountered some of the staff that worked there, right?
I encountered the janitor who opened the door. As we proceeded down the main hallway at the main T intersection there of the school, there was another janitor who said, "We have him."
Yes, sir.
And then we proceeded into the classroom, still trying to find the individual. And then we found Miss Kovac attempting to restrain the child.
And let's talk about Ms. Kovac. When during your response and handling of the situation, you ended up speaking to Ms. Kovac later during your investigation. Do you recall that?
Yeah, well, I wasn't actually doing an investigation. When I spoke to Ms. Kovac the second time, we had been sent to find a teacher and students that were supposedly hiding in a bathroom. In the process of that, I ran into Ms. Kovac, I believe, outside the nurse's office.
And I'm going to show you a display. Brian, could you pull up D57A1, marked for the defense for identification? And Deputy Blythe, I'm going to ask you to look at your screen. I'm going to see if you recognize. This is D57A1. This should not be published to the jury at the stage, just to counsel. And let me ask you, Deputy Blythe, during the time that you responded to Richneck Elementary School, you were equipped with police body-worn camera.
Yes.
And it depicted the events of that day and your interactions with the folks that you talked to, right?
Yes.
Deputy Blythe, do you recognize, you can see on that image, this is police body-worn camera from the day of the incident, right? This is January 6, 2023. Okay, and is this a fair and accurate representation of the Richmond Elementary School as you were going through the hallways?
Yes.
Your Honor, I'd ask permission to publish this to the jury.
I object, Your Honor.
All right.
First, it's outside the scope. Secondly, it's a body-worn camera, so there's going to be hearsay statements that are contained that A, haven't been shared, and B, ultimately are hearsay that are inadmissible in the court.
All right.
Judge, I can address those in turn. First, with respect to beyond
Well,
this.
I've got to see it first. And I can't rule until I see him.
We can voir dire on this outside the jury's presence, Judge,
Yeah,
or
I think we have to. All right, we did our best, folks, but at this point in time, we're going to have to. I'm going to have to see this video, make some evidentiary rulings. We can obviously clear the video. All right, proper foundation has been laid. No objection to that, correct?
No, it's
Okay.
not authentic body camera.
All right, thank you very much. All right, so I'll watch it, then I'll hear argument.
yes, Your Honor.
All right. All right, and let's.
You got a call about, okay, everybody all right?
Everybody's,
Okay, nobody's hurt.
no.
Okay,
They have him, where JT? They have him?
yeah, he's in custody.
Okay.
Yeah. All right, I've got 3 ladies in here.
It's okay. When you're not sure.
That door leads into this office.
Yes, it's a nurse. It was just him. As soon as he shot it, I was walking down the hall and I heard, and I went right in. Abby was in, the teacher was bloody. And she came out. She came out, we moved the kids out. JT. Stood there and I took. JT. I was the one who called 9.
All right, so obviously that's been edited, right? The video's been edited?
Yes, we took the original document and just freeze specific portions, but it's not been altered from its original form beyond segmenting it.
And what about the audio, though?
The audio, to comport with the court's pretrial ruling regarding confidentiality of minors' names, we had our tech professional just censor the minors' names.
All
That's
right,
the
I just
extent of
wanted
the
to make
knowledge.
that clear what we were
Yes, Your Honor.
watching. All right, go ahead. You can stay there. Can you state your objections again now that
Yes.
you've seen that?
Yes, Your Honor. This is past the scope of, first of all, of Corporal Blythe's involvement in terms of what was elicited during direct examination. We talked about him arriving at the scene, locating and identifying the location of a firearm, and that's it. Now, when we get to this portion of the body camera, first of all, the question here is, what's relevant to the context of a body-worn camera in which 3 staff members are talking about? Candidly, I don't know what the relevance is of the substance of the testimony that is being elicited in the video, but to the extent there is any relevance to it, it's the statements themselves, presumably, that they believe are relevant. And those statements themselves are de facto hearsay statements by individuals who are not parties, And there is no exception to the hearsay rule that applies. To the extent they try to argue that it's an excited utterance or a present sense impression to that extent, the issue here is that excited utterance has to be within a certain time-limited period, and the courts have often said within a couple minutes or contemporaneous. And as Corporal Blythe has already testified, it took him about 5-6 minutes to get there. And then we're talking about his response time, and then we're talking about eventually him getting to this portion. And so A, I think it's irrelevant. B, it's beyond the scope of the direct examination. C, there are hearsay statements contained within. And if it's not for the hearsay statements, there's no pertinent issue that is being demonstrated in the context of this video without statements.
Please address those three objections.
Yes, Your Honor. I'll address them in turn. First, with respect to relevance. Well, in reverse order. First, with respect to hearsay, I will gladly, after having Deputy Blythe identify this as his video, mute any volume. I don't need it for purposes of this clip, so that should negate any hearsay objection. And additionally, Judge, this video, this is not beyond the scope of direct examination. Counsel began his examination, Deputy Blythe, by saying unequivocally, I'm going to, quote, ask you about your observations at Rich Neck, quote, your day at Rich Neck Elementary School. That is very, very broad and expansive. Although they focused on just the initial portion of Deputy Blythe's arrival, Deputy Blythe has also testified that he spoke to Ms. Kovac, at least during the initial encounter, and later followed up and had additional interactions with her. This is all within the scope of Deputy Blythe's initial response. It's fair game. It is not beyond the scope of direct, and the court has wide latitude to allow exploration of legitimate issues the jury should hear about. Finally, with respect to relevance, Judge, this is highly probative. First and foremost, I anticipate, and I will intend to elicit from Deputy Blythe, that when he's encountering these individuals, this is going to be the main office. This will be Dr. Parker's office, where you could see on the video there is Dr. Parker present there. She's also there with Miss Amy Kovac and Miss Laura Harris. Those are three folks in the hall, three folks who are in the office, and it will show the layout of the office. I will ask Deputy Blythe about how, when he enters the front entrance of that office, it clearly shows that Dr. Parker, her computer faces away from the front entrance. And in order to speak and interact with Deputy Blythe, she has to adjust and stand and sit perpendicular to him. That's salient to the issues in this case, Judge, because we've heard testimony in the course of yesterday and the day before that when Mr. Sims was in the main office, and also when other individuals went into the office, the way they perceived Dr. Parker was affected by how she was postured, how she interacted with them, and it will influence whether or not the jury has to decide whether or not she was indifferent, whether she did not respond. And this will account for the fact that she was working, that she was focused on her work. It's consistent with the defense theory that she was observing and diligently working. And that this is the layout of the office, this is the nature of it. Just because you come in and she doesn't turn and look at you does not reflect callousness and indifference.
All right, I understand. All right, so hearsay is taken care of by muting that, so that takes care of that. So, Mr. Beniaz, I'm going to agree with you that it is beyond the scope of your direct examination. They obviously have the right to recall him as their witness. I would sustain it on that. Do you have any, now that we know that he's not going to play the hearsay, would you withdraw your objection so we don't have to call him back, or do you want him called back?
No, that's okay, Your Honor.
Okay.
Standing on my objection, but I understand the efficiencies that we can accomplish.
Okay, I appreciate that, and I bet the deputy does too. All right, so legally, once again, I do find that it's beyond the scope, and I do find that it's relevant. So balancing those, however, the court appreciates the withdrawal of the beyond the scope objection at this time for the purposes you are offering, and you are only allowed to offer it for the reasons you've stated. Agreed?
Yes, Your Honor.
All right, very well.
And Judge, for efficiency's sake, with the same witness, I had several other clips from his body-worn camera that I wanted to address. They will primarily focus, I would proffer to the court, his interactions with Ms. Kovac and his discussion with her and prior inconsistent statements she makes to Deputy Blythe.
All right, that I'm assuming you're not going to agree to. Yeah, that.
Good assumption.
Yeah, that I think you'd have to do that in your case in chief.
I understand, Judge, but I want to alert the court And so, very good. My understanding of the court's ruling is, with respect to these, this would require calling him in my case in chief. It's not off the table, though.
Correct.
Thank you, Judge.
Correct. All right, so did you want to keep him on for the purpose that we've agreed on, or do you want to wait to do
That's
all of
fine.
it?
I'm happy to address this one individual clip.
Okay. All right, very well. See if they're ready. And you're able to mute that. All right, excellent. And what number are we going to give this for your
This is D57A1.
57?
57A1.
Oh, defense 57A1.
Thank you, Judge.
Stand for the hearing. And yours in the box.
Oh, thank you.
Thank you, counsel. Appreciate it.
Thank you. All right, you may proceed.
Thank you, Judge. Deputy Blythe, you've testified to your initial response to Rich Neck Elementary School on January 6, 2023. That's what we were discussing.
Yes.
And you testified that during your response, you were going in there to try to find certain individuals and get a handle of the situation, correct? During your response, you were directed to seek out specific individuals, right?
After the shooter was in custody, yes, we had a call. There were people hiding in a bathroom that needed to be rescued,
Yes, sir.
lack of a better term.
And during your response, you were equipped with body-worn camera, right?
Yes.
And the body-worn camera was depicting the events as they unfolded and the folks that you interacted with, correct?
Yes.
Deputy Blythe, if I show you a clip from your police body-worn camera, would you be able to recognize that?
Yes.
Brian, could you pull up clip D57A1 and display that for counsel? And given our prior discussion, Judge, I'd ask to publish it to the jury.
All right, objections noted for the record, but publish permission granted.
And Brian, I would pause at this juncture. Judge, I just want to be clear, if I could address the jury and make note that this has been muted for certain evidentiary reasons, but I nevertheless want them to see and observe.
Objection, Your Honor.
Yeah, you can't explain it to them.
Sure.
But it is muted there, and I will allow you to ask them any questions, and then obviously in closing you can argue whatever you would like to argue.
Thank you, Judge.
All right.
Please continue. All right, if we could pause here, Brian. Deputy Blythe, what we just watched here, this was you entering the main office of Rich Neck Elementary School, correct?
At the time, I didn't realize it was the main office, but it appears to be.
It appears to be the office where you see here on the screen, that is Dr. Ebony Parker, correct?
I'd never seen her before today, but
I understand. But this
didn't
appears
recognize her as who she was, put it that way.
not at the time, but now that we're in court, this is obviously Dr. Ebony Parker, correct? Okay, and then also present in that room were two other individuals. You can see one of those was Ms. Kovac, who you had an interaction with during your response, correct?
Yes.
Now, I want you to just focus here. When we're looking at this image, this was the front entrance this was the main access point to get into this office, right? When you walk through, you had to go through that door in order to get there, correct?
I'm not sure if there's another door to the right or not. I'm not familiar with the office.
Understood. But as you entered the threshold of this doorway, you can see Dr. Parker is turned and faced kind of perpendicular to you, right?
Correct.
Okay. And so if she were facing forward, she would be faced away from you, obviously, right?
Yes.
In order to interact with you and talk with you, she had to turn, right?
Yes.
And you can also see that in front of her is a computer with a display on it, right?
Yes.
And her desk is facing away from the entrance that you used to access that office, correct?
Correct.
Thank you. I have no further questions of the witness, Judge.
All right.
I would move to introduce D57A1 at this time.
All right. Incorporate our prior discussion. Any other objections? All right. It is admitted then as defendant's 57A1. Are you going to have any redirect?
No, Your Honor.
Okay. Did you want him still under subpoena and available for recall?
Yes, Your Honor, and I'll be in coordination with you, Deputy Blythe.
All right, very well. Okay, so you are still a witness in this case, but so I'm not releasing you from the subpoena, but I am releasing you from court today. All right, so they have your number and can reach you in case you need to be called back at some later date. You understand?
Understood.
All right, and still as a witness, you're not allowed to discuss your testimony, okay?
Yes, sir.
All right, thank you very much.
Thank you, Your Honor.
All right, next witness.
Dr. Ann Shufflebarger is our next witness.
You get your stand right here, face the clerk, raise your right hand.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Have a seat up here.
Thank you, Your Honor. Good morning.
Good morning.
You go ahead and state your full name, introduce yourself to the jury.
My name is Ann Shufflebarger.
And Ann Shufflebarger, are you a Dr. Ann Shufflebarger?
I am.
All right, and you are a doctor in what?
Education.
Thank you. Dr. Shufflebarger, I'm going to show you a little roadmap. It's just going to tell us what we're going to be talking about with you today. We can go to the ITVO. I want to talk to you first, if we can publish it, Reed, about your personal professional experience. Then we're going to talk about case retention. In other words, why are you here today to talk to us? And then I want to talk to you about your findings and observations in your professional experience.
Okay.
And so there's enough context. You have reviewed materials and come to findings and observations based upon your review of those materials.
Correct.
And that's specific to the events at Rich Neck Elementary, January 6th.
Correct.
We'll get to those kind of near the end.
Okay.
So first, tell us why you're here in terms of your background.
Okay. I have 38 years of experience working in public schools. I have been a first grade teacher, a reading specialist, worked in central office with both reading programs and overseeing school administration, and then I've been a building administrator, principal, and assistant principal, over all in Virginia Beach. And when I have retired, but since then I do part-time work, fill in when principals are out.
And so there's been a term used during the case about wearing different hats, you know, generally what that means?
Yes.
So you've kind of worn all the hats, or a lot of the hats that people are going to be talking about in this case. You were a first grade teacher like Miss Z.
Correct.
You were a reading specialist like Miss Kovac. Is that a yes?
That's a yes.
Just for him, sorry. You have been an assistant principal like Dr. Parker.
Correct.
And remind me, have you been a principal?
Yes, I was a principal.
I hope we're paying you fair.
Very fair.
Okay. So in your review of the materials, did you ultimately come to findings and observations that you particularly pointed out as it relates to the actions or inactions taken by Dr. Parker on January 6th?
I did.
I want to talk to you. We've heard evidence so far in this case that there was a moment in time in which there was an initial information or sharing of information about a gun or a weapon at Rich Neck Elementary. Are you following where I'm going?
Yes.
And that was revealed in the...
object to the leading.
If you can ask open-ended questions. Well,
Yes.
Technically, they are leading, so I'll sustain that.
Yes, Your Honor. What findings and observations did you come to as a review of your materials related to the first incidents of information conveyed to Dr. Parker?
My findings were that Dr. Parker did not take action that I think an assistant principal should have taken at that time.
And when you say should have taken at that time, tell us, in your opinion and in your experience, what actions we're talking about.
When an administrator receives a report of a suspected weapon, I was trained, and it's written out in most policies and procedures handbooks, that administrator is to take it as a credible threat until you assess the situation and find otherwise. And so when a teacher came and reported that students said that a student had a gun, and it was a student who an hour earlier there had been reports that he was having difficulty and was threatening students at lunch, action should have been taken at that time.
And is it do you have an opinion as to whether that action, lack of action, in your review of the materials, did it stop there? In other words, is that the last time that there was interaction with Dr. Parker about a weapon on campus?
From my reading of reports throughout the day, depositions and timelines and different things, it appears one more opportunity.
Moment, right? And there's been evidence, so we don't need to get into what that is particularly. But that second moment, you say there's 4. What's your view as an administrator in that context, in Dr. Parker's situation, in terms of getting a second notice of a firearm on campus?
Hearing it the first time and not taking action, I don't know, what individuals were thinking at that time. But when it comes back up again, checked the book bag, it's not there, but I'm getting reports that he has something in his pockets. That to me is a huge red flag. Take action. Get the kid secured, search, call law enforcement, alert the principal. There are many things that needed to be done, and none of those were done at that time.
And Dr. Shufflebarger, I mean, we're talking about Dr. Parker's actions, but none of the other teachers called 911.
You know, there's a chain of command in a school, and there are usually policies and procedures that guide that. Teachers are taught report to an administrator. Administrators are the leaders and are trained to take care of that. And it's my understanding that teachers did report it. Several teachers did talk to her about that. And, you know, there's even a handbook provided by Rich. Can I mention that? The staff handbook for Rich Neck Elementary.
We've talked. We can hear the objection.
Objection, Your Honor, that's the exhibit that was provided to date and outside of discovery.
And that is a continuing objection.
Yes, my understanding the court has not ruled on that.
I thought we were going to go ahead and allow her now that the foundation's been set, or did I misunderstand what you thought we were going to do?
I think maybe I misunderstand what we were going to do on that, because that has not been discussed.
This is exhibit.
And it's also beyond the scope of her designation. It was not, she submitted a report, and under the Crane rule, she's limited to the four corners of her report. She did not review that document, and it was not discussed in her report. I have a copy of her designation if the court would like to look at it.
I have that.
Your Honor, I think I can cure concerns and streamline some efficiency.
So you're going to withdraw the question?
I'm not going to withdraw the question because she hasn't really. I invited the objection preemptively because I saw Ms. Douglas out of the peripheral, and so I don't think that there's actually objectionable testimony that's been provided thus far. I would just ask.
She's actually asked you a question.
That's right, and so I'd like to just continue the questioning in the event that we are going anywhere that counsel doesn't think we ought to go. We can of course take it up, but this is Exhibit 108, I think in particular, that we're talking about, that Your Honor permitted questioning as it relates to Mr. Sims yesterday, and so it has been taken up by the court. But ultimately, I think we can roll through this and get through it.
So the answer to your question at this point is no.
Okay.
All right, go ahead.
All right. So, Dr. Shufflebarger, in review of the materials that you've been provided, are there different hats that people wear in the world of administrating school and education system?
Yes, definitely.
And the hat of the assistant principal, the administrator responsible for a crisis management plan, you following?
Correct.
Was that the hat that, in your review of the materials, that Dr. Parker was wearing?
Yes.
And in your review of the materials, when that person wearing that hat has received the second notice of information as it relates to a firearm on campus, what's your opinion as to how, if at all, she responded or what her actions amounted to at that time?
From the things that I read, no action was taken. There was discussion about him putting it in his pockets and the size of the pockets, but no action was taken.
And from your perspective and in your expert opinion as a former administrator wearing that hat, what's your view and observation of what that amounts to? Is that's failure to act in the course of safety for the school. That's endangers folks. When you hear something like that, I know I said it before, you're expected to take it credibly. Here's a second report that people think the student has a gun. Action needed to be taken to prevent possible safety issues. And in your opinion, is that action should have been taken by Dr. Parker?
Yes.
And was that the last time, in your review of the materials, that Dr. Parker was informed of a threat of a firearm on campus?
No, it was not. There was a third time involving a phone call between Mrs. West, who was a first grade teacher, and Mr. Sims, who was answering phones in the office. I know depending on different things that I read.
We don't have to get into,
Okay.
because the jury's already heard them
Okay.
testify. We don't,
But there was a phone conversation, and Mrs. West asked, had the student been searched? Or had the book bag been searched? I'm sorry, had the book bag been searched?
and so in your review of the materials, there was sort of a third moment in time in which Dr. Parker was faced with a decision or a choice.
Yes.
And in your opinion, as an administrator and as an educator in this field, how do you characterize her response? Did that meet the standard? Did that breach
No,
the
it
standard?
did. It breached the standard of care and of job responsibility.
And was that the last time, based upon your review of the materials?
No, there was a fourth time when two different teachers were at her office talking about a first grade student reporting that he had seen something and more concerns. And those staff members took it upon themselves to ask if they could check his person, check the student's person. And they were told, no, mom's coming in a little bit. No, we don't need to check at that time. And in my mind, that's quite a bit of inappropriateness, of a failure to act, because here comes more concern, more discussion, another report, and no action taken, and stopping others from taking action.
And so if we were to separate those moments in time, Dr. Schuffelbarger, in your opinion, and we were just talking about an initial report earlier in the day that you talked about, number one, is it your opinion that that and that alone and the failure to act under that circumstance breached the standard?
Yes.
And if we didn't even have that, and we're talking about the second moment in time, and if that was all that you had reviewed, is it your view that that and that alone would have been enough for her to fall below the standard?
Yes.
All right.
Guiding
It is
the test.
technically leading. I'll just ask you to rephrase.
Yes.
Now, were you on the second? I know you asked her about the first.
Yes.
This is the second incident that you're on at this point?
Yes.
All right. Thank you.
And as to the third and fourth?
I feel like each time it's brought up again, another person has shared concern, another student has shared that he's scared because of the conversation about it. When you look at that in totality, it's almost shocking, the lack of action there, how things were not followed up on. It really does breach the standard of care.
Dr. Schuffelbarger, are all the opinions and conclusions that you've provided held within a reasonable degree of your expertise and profession?
Yes.
Those are all the questions I have, Your Honor. Thank you.
All right. Thank you. All right. Any cross-examination questions?
Yes, Your Honor.
All right.
Hello, Dr. Schuffelbarger.
Hello.
Your tenure in the Virginia Beach public school system was entirely in education, correct?
Correct.
40 years?
35 full-time, 3 part-time.
So about 40 years?
Yes.
And you retired in 2022?
Correct.
In those almost 40 years, you never once had a elementary school student bring a loaded gun into the school, did you?
No, I did not.
And Dr. Schuffelbarger, you agree that an assistant principal of the school is not solely responsible for school safety, correct?
No.
It's a team approach.
Correct.
And it also involves the teachers in the classroom, correct?
Correct. The assistant principal is the leader of that team.
And the principal's involved as well, correct?
Correct.
And the teacher in the classroom is actually the first line responder. You've heard that term before.
Yes.
Now, you've seen in the materials that you've read related to the case that Dr. Parker was involved with standardized testing that day?
Correct.
And there are strict rules that govern standardized testing, correct?
Yes.
And the assistant principal is the school testing coordinator.
Generally so, yes.
And the assistant principal is responsible for setting up the secure environment for the testing?
Correct.
And these tests are given online?
Yes.
And it involves the assistant principal being at her computer.
To get things started, yes.
And throughout the testing
Checking
process?
in on it throughout the day. It doesn't require being at the computer all day.
But it requires being at the computer a fair amount
Certain times, yes.
because of the security of the testing tickets, correct?
Right, but an administrator can leave the office as long as they are locked up and secured so that other people cannot get to the testing tickets.
Understood. And this was going on concurrently on January 6th, correct?
Correct.
And there were other discipline issues going on
Yes.
January 6th. You read about those?
Yes, I have.
And Dr. Parker had to interject and get herself involved in those situations. You read that?
Correct, yes.
And that's in addition to wearing all the other hats that an assistant principal wears.
Yes,
And I think you agree with me that an assistant principal wears a lot of hats
I do agree with
in
you.
a management of an elementary school. You agree with that? Now, you told the jury about what Dr. Parker didn't do. You would agree that an assistant principal must use his or her judgment or discretion in determining whether reports about a student are credible.
But part of that involves assuming credibility and checking to see if it is indeed. You're to assume credibility until you check and assess to find otherwise.
Until evidence tells you otherwise.
Correct.
Okay, but that does involve the use of judgment and discretion. You would agree
Yes,
with
I
that?
would agree with that.
Okay. And the assistant principal can't be everywhere all the time, correct?
Correct.
And the assistant principal has to rely on other staff members and other teachers in determining whether reports are credible, correct?
To some degree, yes.
And you would agree that the first report that Dr. Parker received regarding JT was from Ms. Kovac?
Yes.
And Ms. Kovac investigated those reports before she went to see Dr. Parker, didn't she?
Correct.
Ms. Kovac is a seasoned educator, isn't she?
Yes.
Over 30 years.
Yes.
And she worked with JT daily.
Yes.
She knew him well.
Yes.
And Ms. Kovac stayed in the room with Ms. Werner and her class for a while to investigate the reports about whether JT might have a weapon.
Yes.
Ms. Werner was also in the room while this was going on. You read that?
Yes.
They were the first line responders to the reports about JT having a weapon, correct?
Correct. First line responders as teachers are to report it to administration.
Right, but that's a different question. I'm
Okay.
asking you if Ms. Kovac and Ms. Werner, who were in the room when this happened, were the
Yes.
first line responders to the information reported by the two students.
Karen, I'm just going to object to preserve our motion in limine regarding argument as it relates to duties owed by individuals who are not the defendant in this action. I think we're venturing into an area of asking what is an obligation there, which Your Honor has ruled is not an issue for the court and has not been pled.
Your objection is noted and, it's made contemporaneous, but I don't think we're into the grounds that I have ruled yet that are inappropriate. All right, go ahead.
See, so you would agree, you read in the materials that Ms. Werner and Ms. Kovac were in the room with the student.
Correct.
Ms. Kovac did not confiscate JT's backpack.
She did not at the time that he was in the room.
Ms. Kovac did not.
I'm sorry, can you repeat that question?
Ms. Kovac, the reading specialist, just like you, she did not confiscate JT's backpack after her investigation, correct?
Correct.
She did not remove JT from the room.
She did not.
And Ms. Werner did not confiscate JT's backpack, did she?
No.
And Ms. Werner did not remove JT from the room.
No.
And she had removed him from the room a couple days before when he had thrown her cell phone, correct?
I don't know about that. I have not reviewed that recently.
You haven't reviewed it recently?
I can't speak to that right now.
Can't speak to it right now. At that time, Ms. Kovac went to talk to Dr. Parker, correct?
Correct.
And at that time, Dr. Parker would have learned that JT had been permitted to go on the playground with the other students.
My understanding is that when she went down to the office, they were getting ready to go to recess. And she said that she would go back and check the background backpack when they went out.
Right.
So I don't know the exact, was she there when he went out, or did she leave the room before? I don't know the answer to that.
My question is different.
Okay, thank you.
Based on what you read, when Ms. Kovac went back to Dr. Parker's office to report on her investigation, you read that
after
she
the
would have known that that Ms. Kovac had investigated, chose not to remove him from the classroom, correct?
Yes.
Chose not to confiscate the backpack,
Yes,
and that he was off to the playground with the other first grade students.
yes,
And would you agree that that is information that tends to disprove that there's a credible threat?
no, I would not agree.
Would not agree with that. Now, Ms. Kovac goes to speak with Dr. Parker and at some point searches the backpack.
Yes,
And that was based on a discussion between Dr. Parker and Ms. Kovac, that the backpack would be searched.
yes,
And then there were some other conversations that you talked about that day to Dr. Parker, correct?
correct.
But you were not there for those conversations. You have no way of knowing what information anyone specifically conveyed to Dr. Parker.
That's correct.
But what we do know is some of their actions that day. You do know that, correct?
Okay,
And then you told the jury that there were 2 staff members. That was the last opportunity for Dr. Parker. The 2 staff members, and they were teachers, I believe is what you said.
yes,
Do you recall that being Mr. Rawls, the guidance counselor?
yes.
And he wasn't a teacher, was he?
Okay, that's an instructional position, but it is different from a teacher. You're
was a
correct.
guidance
He was a
counselor.
guidance
He
counselor.
was on the threat assessment team,
Okay,
right? And you read Mr. Rawls' deposition,
I did.
and you read that he had not determined it to be a credible threat when he spoke to Dr. Parker about searching JT, correct?
That's what I read, yes.
Okay. And he spoke with Dr. Parker about searching little 6-year-old JT, and he not sure about what was said that day, but Dr. Parker didn't refuse that JT be searched. She just wanted to wait till his mother got there to go through the rest of his things. That's what you read, correct?
Yes, ma'am.
Now let's talk about student searches.
Okay,
You would agree that the decision whether to search a student is a judgment call for an administrator to make based on the information known at the time.
correct.
Age is a factor in determining whether to body search a 6-year-old, right?
Age and a lot of other things are a factor.
Sex of a student is a factor, correct?
Correct.
And you want to handle the student with as much dignity as possible so that you don't upset them, correct?
Absolutely.
You must also consider legal issues involving right to privacy.
Correct.
And during your tenure in the Virginia Beach public school system, it was preferred that a parent be present for a body search of a student.
Yes,
And here, Dr. Parker did not deny Mr. Rawls searching the student, but wanted to wait for the mother to get there because she was coming soon. Correct?
that is what I read that she said.
You were answered a few questions about Newport News procedures and documents, but you were in Virginia Beach, correct?
Correct.
You don't know anything about training in Newport News on any documents that they have.
The only things I read, there was a multi-crisis handbook that I read about Newport News procedures and the Rich Neck handbook, and I don't know if I can discuss either of those.
But you don't know how training is done
No.
in Newport News.
No,
And you don't
you're
know
correct.
how Dr. Parker was trained
You're
about
correct.
those documents.
Yes.
Dr. Shuffleberger, you came to be an expert in this case with Mr. Bright's sister-in-law, correct?
Correct.
You'd never been an expert before. You've never sat on the witness stand as an expert witness, have you?
No, ma'am.
And you're charging $500 an hour to sit here today, correct?
Correct.
And at the time you reviewed this case, you knew about the outcome at Rich Neck Elementary School on January 6th, didn't you?
I did.
You knew the outcome. And you yourself agree that it's unfair to judge someone's conduct with 20/20 hindsight vision, correct? You agree with that.
I can see that, yes.
And you agree that Dr. Parker, in evaluating information regarding a 6-year-old having a loaded gun at school, something that never happened to you, she did not know the outcome that day, correct?
Correct.
I have no further questions.
Redirect?
Yes, Your Honor. Dr. Scheffelbarger, there was a question about standardized testing at the beginning of the cross-examination. Do you recall that?
Yes.
And I think the question was, you have the obligation of the assistant principal is to secure an environment for testing. Is that right?
Correct. Yes.
Can you imagine a circumstance that jeopardizes a secure and safe environment for testing more than having a firearm on campus?
No.
And you were also asked about other disciplinary events that were taking place at the school.
Yes.
And so it's your observation, I think, that Dr. Parker was attending to some things on campus
Yes.
and not the firearm.
Correct.
Is there anything in an administrator's life that is more important than understanding and determining the validity of a threat of a firearm on campus?
I can't think of anything that would be. Being a building administrator is a hard job. You talked about wearing lots of hats, and absolutely administrators wear lots of hats and have to handle things that happen quickly. You may have a plan, I'm going to do this today, and you never get to it because it's almost like a triage situation. You have to determine what's more important, what is more urgent at this time. And a report of a firearm stops everything. You stop, you investigate, determine if it's credible, and then you can move on with your day if it's found not to be.
And you were asked about investigating. I think you were asked about Ms. Kovac's investigation. Do you recall that question?
Yes.
Whose job was it to actually do the investigation?
An administrator.
Dr. Parker.
Dr. Parker was the one it was reported to.
Whose job was it to actually confiscate the backpack?
Dr. Parker's.
Whose job was it to secure the child?
Dr. Parker.
This is beyond the scope of her designation. None of this is designated for her testimony.
I'm going to overrule that.
Whose job was it to contact law enforcement?
Dr. Parker.
Whose job was it to search the person?
Dr. Parker.
And there was a question about the dignity of a child, a 6-year-old child.
Correct.
Recognizing the dignity of a child, is the dignity of a child more important than the safety of the individuals on campus when there's a report of a firearm?
I think you can manage both. You can handle all the things that need to be handled with the student who potentially has a weapon in a dignified way and protect the privacy and the dignity of the child in a way that other children don't see it. But you can't ignore it, and we should not ignore it.
You got to get to the bottom of it.
Yes.
And
find
Dr.
out.
Parker never got to the bottom of it.
No.
Thank you.
Briefly on that.
Follow up. You just testified that a report of a firearm stops everything, correct?
Yes.
Stops everything for everyone in an elementary school.
For the administrator who receives the report, they need to kind of stop what they're doing and handle that report right away.
So you're telling this jury that the report of a firearm in a school stops everything for the administrator, but the teacher, the first line responders can go about their business. That's what you come in and telling this jury.
And argumentative.
Overruled.
That's.
I'm saying it's the assistant principal's job to stop and take care of it. Their job is to report, and the assistant principal's job is to act.
You would agree that other individuals involved did not stop everything that day, correct?
No.
Ms. Kovac didn't stop everything, Ms. Werner didn't stop everything, Ms. West didn't stop everything, and Mr. Rawls didn't stop everything, did they?
No.
No further questions.
Thank you. All right. Is she going to be needed to testify again?
Not from us, Your Honor.
All right.
I don't think she's under subpoena from the defense.
So may she be excused?
She may be.
All right. You are excused. Thank you for your testimony today. Because this is an ongoing case, please do not discuss your testimony with anyone.
Absolutely.
All right. Thank you. All right. She may be excused. All right. Is now a good time to take a break?
Yes, Your Honor.
All right. Let's take our morning break, about 10 minutes if we can. I would appreciate that. And then I'll discuss. I would like you. We're not in recess yet, but you may take the jury, Deputy Hospital.
one way guilty.
All right, what is the plan for the rest of the morning and the afternoon, if you are able to tell me?
Lunch is scheduled to be here at 11.
What is lunch?
Go ahead.
We have mostly treaters lined up. We do have another staff member that we may not call just based upon cumulative nature of testimony. And so we are going to go check and see which providers are here, and then hopefully put another witness on before lunch if possible. But if we need to jump to lunch, it's your option.
No, I definitely want to get at least one more witness in.
Great. So we can do one witness before lunch. Dr. Munn is present.
And then lunch and then doctors this afternoon?
Yes, Your Honor.
Right. Any problem with any of that?
No, Your Honor.
Okay. Plan on proceeding that way. All right, we'll take a 10-minute break, which means 15 minutes in lawyer time. Thank you.
Please rise.
To take up before we bring the jury back? All right, very well. Bring in the jury.
Jurors in the box.
Thank you. All right, folks, I think we're going to hear from one more witness, then we'll take our lunch break, and then we will proceed with the afternoon after that. All right, call your next witness, please.
It's Dr. Munn.
I can get you to stand right here, face the clerk, raise your right hand.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Please have a seat.
Watch your steps, stepping up.
You may proceed.
Thank you. And can you please state your name for the jury?
Daniel Munn.
And tell the jury, how are you currently employed?
I'm the chief of surgery at Riverside Regional Medical Center.
And how long have you been in that position?
About 10 years as the chief of surgery.
And were you there in that capacity on January 6, 2023?
I was.
Okay. And before we get to that date, can you briefly tell the jury about your medical background, your educational background, I should say, so the jury can understand a little more about you?
Sure. I'm a general surgeon by training and specialize in trauma surgery and surgical critical care. I'm the chief of trauma at Riverside and have been there for 14 years total. I was in the military before that. That's where I trained to be a trauma surgeon in the Navy.
And where did you go to school?
To Wake Forest.
And after Wake Forest, were you there for all of your education?
Yes, for undergrad, graduate school, and medical school.
And since that date, have you worked in the medical field?
Yes.
And do you have a specialty?
Yes, trauma surgery.
And can you explain to the jury what exactly that means?
So of the general surgery subspecialties, general surgery includes basically abdominal surgery, breast surgery, skin cancer, things like that. And trauma surgery focuses on pretty much the rest of the life-threatening injuries of the body, but we take care of all injured patients. So it might be car accidents, gunshot wounds, stabbings, things like that. Even falls from standing, falls downstairs, things like that.
And Your Honor, at this time, I would like to tender Dr. Munn as an expert in the field of trauma surgery, general surgery, and surgical critical care.
Any objections?
No objection, Your Honor.
So qualified.
Thank you. Now I would like to turn your attention to January 6, 2023, and the couple days thereafter. Do you work with a team of doctors?
Yes, we have 6 trauma surgeons and 3, nurse practitioners basically that work with our team. And so I think Dr. Chapp has already testified, but he was the primary surgeon on for trauma at that time. And then the rest of our team were taking care of her the rest of the time that she was in the hospital.
And when you're saying taking care, I should make it clear in the record, you're referring to Abigail Werner, correct?
Yes, exactly.
Okay. And you see her in the courtroom today?
I do.
And can you tell the jury, when did you care for her that week that she was in the hospital?
I would have to look at the record to see exactly when we crossed paths, but basically we all work as a team and cover all of the patients in our, on our service. So.
And so what was your role that week when you saw her?
Just supportive care, managing all of her medical issues, managing her critical care. She had a chest tube that we had to take care of, and that is a big part of the focus for our team. But all of her injuries are under our, we're the attending surgeons for her and the primary physicians for her. So we took care of all of her medical needs while she was in the hospital.
And just to help you as you're walking the jury through what you did in her injuries, I'd like to share, and if I can publish it with the jury, Your Honor, I have shared it with opposing counsel. I don't believe there's an objection. It's going to be a demonstrative exhibit. We'll be referring to it as MV13.
Any objection as a demonstrative exhibit?
No, Your Honor.
Okay. So just let me explain to you, ladies and gentlemen, demonstrative exhibit is something that you'll be able to see that assists you in understanding the testimony of a witness, but will not be going back with you to the jury room. All right, so if that helps you taking notes or not. Thank you. You may proceed.
Thank you, Your Honor. And with your permission, it can be published?
You may.
Thank you. And Dr. Munn, do you have that on your screen in front of you?
I do, yes.
Okay. And can you walk the jury through what this illustration means to you in regards to Ms. Werner?
Absolutely. So if you look at the left side of the drawing, it's basically sort of a mock-up of a person standing up or, maybe laying down, but basically the whole torso. And the 2 cutouts on the right are images that kind of reflect what we would see with a CAT scan. And so the top one is actually her CAT scan. And then the other one on the bottom is sort of a cutout of what it would look like to slice her like a loaf of bread. So in a CAT scan, her head is into the screen above us, and then she's laying on her back. And then her legs would be sticking out of the screen towards you. And so that, as the CT scanner presents images slicing through the body like a loaf of bread all the way from the head down to the feet. And so they're basically referencing back and forth between the left side of the total of her torso and the cutouts on the right are basically showing you where the bullet went in to the left chest. It went through her ribs, which are to the left of that. So if you look at just the upright one on the left, it's probably easier just follow that course of the bullet. Yeah, sorry.
You're welcome to ask him to step down if you'd like.
Yes, that would be fine. Sure.
Having him correct them. Ms. Douglas, any objection to having him come down? All right.
So if you would
Thank you.
Yeah, and just make sure you speak up. All right, thanks.
Oh, okay. Yeah, it might be easier if I just stand at the screen, if that's okay.
Yes. Okay. Thank you, doctor.
So again, this is the trajectory of the bullet going into the chest, going through one of the ribs, and then through the lung tissue, and then ending up behind the heart, just along the course of where the aorta, or the major blood vessel of the whole body is. And so again, when we're looking at this same image with her sliced like a loaf of bread, it kind of goes in through the side of the chest up here, and then ends up behind the heart, which is this area right there. So the big black areas on both sides are the lung tissue, and then all of this is blood that's collected in the chest from where the injury is. Again, the bullet is this super shiny thing with the arrow pointing to it. It is backed by her spine and very close to the aorta, which is the biggest artery in the body. So if you look at this image, the aorta comes off the top of the heart, it goes down to the lower part of the body, provides all the blood supply to the rest of the body. And so this bullet is positioned, if you look at this blow up here, it's about 2 centimeters from the aorta and abutting her vertebrae spine. So, I'm not sure if you want to show what 2 centimeters is exactly.
Oh, yes, if you want. Now, Dr. Munn, are you done with those? Do you want to, I can.
No, I think that is pretty much it. This image here gives you a better view of what the CAT scan shows because it shows the tissue more realistically. And so this is her lung that has collapsed and shrunken down because it has a hole in it. And that hole has bled into her chest and allowed for air and blood to leak out into the space around the lung.
Thank you. And then if you'll have a seat back, we'll continue questions. So can you tell the jury the significance of the blown up image where it shows the bullet 2 centimeters from the aorta?
So there are several things about the way this bullet went in that are life-threatening. Certainly the injury to the lung, where I described that it has collapsed. Any human being can bleed to death from that level of injury to the lung. But again, where this bullet ended up, it went past the heart and just barely missed it. And then also ended up within 2 centimeters of the biggest artery in the entire body, which, patients would bleed to death in seconds from an injury to that vessel.
And Your Honor, if I may, I do have a ruler just to show the jury what 2 centimeters looks like. If I could approach just so they can understand the measurement, Your Honor, I'd ask for leeway.
Any objections?
Object to the relevance, if this is cumulative at this point anyway.
All right, I'll overrule it. She can show the jury what 2 centimeters looks like.
Thank you, Your
on
Honor.
the
I
ruler.
appreciate that. The jurors, you can see on here. This is the number 2 right here.
The ruler's not going back with you all.
Bring that back to my. And Dr. Munn, you had talked about the lung collapsing. Can you tell the jury a little bit about that injury as well?
So this is something that we commonly treat that is a life-threatening injury, but the treatment doesn't seem that significant because basically the treatment is to put a tube in and re-expand the lung by sucking out the blood and the air that's around the lung. And so we often do not have to do surgery to get into the chest and fix this problem because the body heals very well when we re-expand the lung. But it is still a very significant injury and something that is can oftentimes cause a patient to pass away at the scene where they're injured.
And the lung, when it collapsed, is that actually scarred to her chest? Can you explain that to the jury?
So the way that we get it to heal is by putting that tube in, it creates a scar that causes the lung to re-expand and stay expanded. And so over that healing process, if we took the tube out too early, the lung would collapse again and she would have difficulty breathing and we would have to put another tube in or potentially do surgery.
And so what does that mean for future surgeries?
So now, as a result of the injury and the treatment for that injury, her lung is scarred to the chest wall. And so that means that anytime, if she had any other injury to that side of her chest, or if she needed surgery to that side of her chest for any reason in her lifetime, we would be going through scar tissue to get to whatever that is. So it limits our ability to treat her for other problems that might affect that side of her chest.
And Dr. Munn, where is that bullet that went into her body?
It
Is it still there?
Yes, it's still in her.
And why was the bullet not removed?
So for something like this, it is actually way more dangerous to remove the bullet than it is to leave it in place, because all of those structures that I described that it's so close to are very difficult to get to. And so we leave it in place, assuming that it hasn't caused any additional harm at this point, now that she's stabilized from it, and hope that it won't cause any further harm going forward.
And are there a lot of other people in situations like that where you can understand what that looks like for her going forward? Or is this a unique injury that you've seen?
Your Honor, object, it's beyond the scope of his records. There's nothing in his designation about this type of testimony.
You have a response?
Your Honor, I will certainly keep it focused on her injury, and he is designated to talk about the injury of the chest and the bullet inside the chest and what that means for her. But I can narrow that question a little bit more, Your Honor, if you'd like.
All right, sustained with leave to re-ask.
Thank you. So, Dr. Munn, where the bullet is in Ms. Werner, what does that look like for future injuries that she could have or future needs for diagnostic exams?
So there's no way to provide evidence of what could happen over a lifetime, really, because we can't study all of the patients who have projectiles in them. But we know that they typically don't cause harm when they're in a location that is not near something that's moving. But there are certainly events that could cause this bullet to move if she was under a significant impact of some sort. And the thing that we worry about the most really is something like needing diagnostics testing for MRI or something like that, where she has metal in her and an MRI requires using a huge magnet that can cause the metal to move or heat up. And so it would basically prevent her from being able to have an MRI for the rest of her life.
So in the future, if there was a need for a diagnostic testing of some sort, if there was a concern of anything involving breast cancer or things of that nature, is she going to be able to have an MRI?
Your Honor, this is getting far afield. It's also cumulative. He's already testified to that.
I'm going to overrule it just for this question, but this will be the last question.
Yes, Your Honor.
And
Thank
that
you.
line.
Understood.
It does apply to my specialty as a general surgeon as well. And yes, for someone her age, a female patient her age, it would be concerning that she might have to have an MRI at some point. The most common reason would be breast cancer, because it's very common in women, but also anything else that might require additional imaging. And also, just if we were concerned about the fragment moving, one of the studies that would help us with that would be an MRI, which we wouldn't use for her.
Okay. Thank you. And you saw her on January, when she was initially in the hospital, and then you've seen her January 30th of 2023, correct?
Yes.
And then you saw her again February 6th of 2023, correct?
Yes.
Okay. Can you tell the jury, is there any future needs for her to see you? What would that look like in the future if she needed to meet with you? For what reason?
Sure. So the initial follow-up was mostly to examine her for her recovery and make sure she wasn't having any ongoing complications, the most common of which would be pain from her rib fracture, which she did have when I saw her in follow-up. And then again, if there's anything that changes over the course of any period of time, really throughout her life, if she has complications or concerns about her breathing, then she would come to see us for that.
And Dr. Munn, were all of your opinions testified today to a reasonable degree of medical probability?
Yes.
Okay, thank you. And do all of the injuries that you discussed today related to the gunshot on January 6, 2023, the wound to Ms. Werner?
Yes.
And are the injuries that she has today, sitting in this courtroom, permanent in nature?
Yes.
Thank you, doctor. he'll answer any opposing counsel's questions.
Cross-examination.
Just a few questions. Dr. Munn, if the records reflect that you have not seen Ms. Werner in over a year, is that consistent with your recollection?
Yes, that's correct.
Thank you.
Other questions?
Okay, no further questions. All right, may he be excused to go take care of the citizens of Newport News.
Yes, you may, Your Honor.
All right, thank you for everything you do. All right. All right, is there a witness we can do in about half an hour, or are you ready to do anything else at this point?
No, Your Honor, I think the next one's going to be longer than a half hour.
Okay.
So,
All right, you agree with lunch break at this point, Ms. Douglas?
That's fine, Your Honor.
Okay. All right, ladies and gentlemen, we will take our lunch break for the day. We will try to resume testimony at 1 o'clock. All right, thank you. Anything to take up after they leave? No? Okay.
What I'm here for.
All right, nothing else being taken up at this time. The court will stand in recess till 1 o'clock. Thank you. Call the next witness?
Yes, Your Honor.
All right.
Your Honor, we're running a little ahead of schedule, so we intend to call Hannah Werner at the end of the day, who is an anticipated witness for tomorrow. We notified defense counsel at lunch. If they object, do not want her to be heard today, wish to have her heard tomorrow. It's their objection, I'll let them be heard.
All right.
Your Honor, just in terms of that, we didn't expect her today, so we weren't prepared for her today. But the other issue is she's the one that created the GoFundMe for Ms. Werner, as opposed, in addition to a T-shirt sale fundraiser. And I would like to be able to ask her about that. My understanding from the motion in limine hearing is that the court ruled that we could not ask about amounts, but that we could ask about the creation of fundraisers. So I would like to be able to ask her about that. I think it goes to her bias.
All right, and I ruled on that already, right? Yeah.
You did, but I did not want to run afoul of the court's ruling and cause a motion for a mistrial. But I wanted to make sure, because we discussed the GoFundMe in the context of just the general evidence at trial, and then we also discussed it in the context of the questionnaire, and the court was very careful to word that, so I wanted to make sure.
Yeah, as long as you're in line with what we've talked about
You just
in
don't
order.
mention the amounts
Yeah,
that were
exactly.
created. But I can ask her, did you create a GoFundMe fund?
Absolutely.
Okay. Thank you, Your Honor.
Okay. All right, and I'll permit you to run your case as you see fit, and if we have time today before my normal closing time, then we'll put her on.
Yes, Your Honor.
Okay. All right, call your next witness.
We have Dr. Anderson, who is standing in the hallway.
All right, very good.
Get the jurors there. Oh, yeah. Who need, I mean. Please stand for the juror.
Nine jurors in the box.
All right, thank you, Deputy. Okay, ladies and gentlemen, we are about to begin our afternoon session. All right, please call your next witness.
Next witness is Dr. Romney Anderson. Witness has not been sworn in, Your Honor.
If I can get you to stand right here, face the clerk, raise your right hand.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, Dr. God?
Yes, ma'am.
Thank you.
This way.
Have a seat next to me.
Watch your stepping up.
Yeah, please, court.
You may begin.
Doctor, could you tell the ladies and gentlemen of the jury your full name, please?
Sir, it's Romney Christian Anderson.
And you are a medical doctor?
Yes, sir.
What is your specialty?
Orthopedic trauma.
I want to go through briefly, if I can, your resume, curriculum vitae, so the jury will understand your expertise, if I could. When did you graduate from med school and from where?
1996 from the Uniformed Services, University of the Health Sciences.
I did want to ask one question. You have a Bachelor of Science degree in what?
Nuclear physics.
And then you decided to go to med school after that?
I spent 7 years in the infantry, and then I went to medical school.
All right. Now, I want to talk to you about the different jobs you held as an orthopedic surgeon. I take it you became board certified in orthopedic surgery at some point in time?
Yes, sir.
And where have you worked in the field of orthopedic surgery?
So once I finished residency, I went to fellowship at Shock Trauma Center in Baltimore for a year's fellowship in orthopedic trauma. Then I came back to Walter Reed during the war and helped out with the trauma there. During that time, I worked 1 weekend a month up at Shock Trauma, helping them out as well. And then I worked at a number of little various hospitals doing hip fractures and things on the weekends to help them. When I retired from the military about 11 years ago, or 10 and a half years ago, I came down here to Newport News and currently work at the Riverside Regional Medical Center.
Did you become the chairman of the Department of Orthopedic Surgery at Walter Reed National Hospital?
Yes, sir. I did that for the last 6 years I was there.
And are you the chief orthopedic surgeon at Riverside Health System?
I gave that up recently.
But you were chief for how long?
I did it for a decade, then gave it up.
Have you published in the field of orthopedic and orthopedic trauma?
Yes, sir.
Without going through what appears to be a lengthy resume, could you give the ladies and gentlemen of the jury a rough idea about how many articles you have written, how many chapters of books have you written on orthopedic trauma?
I haven't reviewed that recently, but there's probably 70 to 80 peer-reviewed publications, 10 to 20 book chapters, and then there's some other articles as well, and there's probably 100 total publications.
Have you been working in the field of orthopedic surgery once you started? Basically, once you became chief of Walter Reed, since that time you've been an orthopedic surgeon?
Once I finished my orthopedic fellowship, that's what I did, yes. And during residency, I just did orthopedic surgery.
And you've been in orthopedic surgery and treating regular patients since that time?
Yes, sir.
Your Honor, at this time, I'd like to tender Dr. Romney Anderson as a specialist in orthopedic trauma.
Any objections?
No objection.
Without objection, so qualified.
Dr. Anderson, I take it you were working at Riverside Hospital when Abigail Werner became a patient?
Yes, sir.
And I'm going to try to walk through what you've done with her surgery, but your primary focus, I believe, was on her hand?
Yes, sir.
And when you saw her for the first time, was that on January 6th or on January 3rd?
Can I...
Yes, feel free to review any of your medical records or notes. We had, just so you'll understand, Dr. Munn testified, who was the chief trauma surgeon at Riverside, who I know did see her with the other trauma doctor. At some point in time, I believe they testified that orthopedics needed to come in to work on her hand. I'm trying to determine whether you were on January 6th or on January 7th, if you know.
I believe I saw her in the intensive care unit on the 7th of January. The morning of the 7th of January.
Tell the ladies and gentlemen of the jury, if you would please, roughly what did you see for purposes, and I'm going to go general and then I'm going to show you some medical illustrations.
Yes, sir. So it was...
describe it for the jury, please, if you could.
Yes, sir. It's a devastating hand injury with a significant amount of bony injury or bone fractures, as well as a number of soft tissue injuries that were associated with that.
When you say soft tissue injuries, just tell the jury what are soft tissues of a hand, not the skin, I take it.
There's skin, muscles, ligaments, joint capsules, nerves, blood vessels.
And have you seen those types of injuries in your past?
Yes, sir. This, we take care of a lot of stuff at Riverside Regional Medical Center, but on a, if you stratified these in a scale of 1 to 10, this was a more closely associated with a 10 type injury, which we were seeing frequently during the war.
And what war were you treating orthopedic surgeon injuries with bullet wounds?
OEF, OIF, and Iraq and Afghanistan.
All right, I have shown you and shown counsel before some medical illustrations that were based on x-rays as well as surgical reports, and you have seen them, I believe?
Yes, sir.
Without, it's MV1 through MV9. I'm going to show them to you as a group first, and it'll help us move faster. May I approach, Your Honor? Are these the medical illustrations that were shown to you, and do they accurately reflect Abigail Werner's injury, and would they help you in trying to describe to the jury your treatment of her?
Yep. Yes, sir. These are the ones I reviewed.
And I have MV1, please.
Now, are these going to be offered into evidence?
These are for demonstrative purposes only,
These are
Your Honor.
demonstrative as well. All right, so they're not going back to the jury room, okay? Any objection, by the way, Ms. Douglas?
Not to the demonstratives.
Okay, thank you.
MV1 can be published for the jury. At some point in time, and I believe it's on your screen as well, Doctor, and at some point in time I might ask you to step over to the screen, but for now, they've got a large screen there. Could you tell the ladies and gentlemen of the jury what the upper left-hand, let's see if I can get this done. Am I doing it all right? Hold on one second. What does this picture show us of January 6, 23? This is an actual X-ray of Abby's hand, correct?
Yes, sir.
All right, now you'll see where there are lots of white spots here. Could you tell us what they are?
So the things that are bright white, those are more radiodense, and so X-rays don't go through them, and they show up white. Those are metal fragments of the bone of the bullet.
So those are the bullet fragments that struck her in the hand.
Yes, sir.
And all of those white dots are bullet fragments.
The dark or the bright white, the more gray dots are bony fragments.
All right, let me look at, I take it on the bottom left, that's just a side view of the exact same bony fragments and metal fragments.
Yes, sir, a lateral view.
All right, so looking at this picture of January 6, 23, the medical illustration on the right, could you help us distinguish between the bones and the bullets in this diagram?
So the gray items marked as bullet fragments, those are the bullet fragments. The kind of yellowish tan flecks are bony fragments.
I may have trouble because I don't see yellow.
Or it's a gray, tan, whatever. The rest of the bones, like the finger bones, those little fragments that are a little redder down where all the bony breaks are.
Here?
There, that whole region, or if you'd like, I can come point it out.
I'm going to save you because I don't want you jumping back and forth because we have...
But all through that region you just circled are little bony fragments as well as metal fragments.
And what did you do as the orthopedic surgeon for that hand to try to stabilize Abby?
So the initial, when you see an injury of this magnitude, your initial treatment is not to get everything put back together right away. It's to stabilize things. So we brought her to the operating room for an irrigation and debridement. That is just to try and remove any contamination in there to reduce the infection risk over time. And then as you can see, some of those bones have no stability at all, and some look like they're short. So we needed to bring those out to length and pin them so that when we went back to do definitive fixation, we'd have the bones out to length and they wouldn't be scarred and short.
When you say you lengthen them and then get them ready for, what are you using?
We use K-wires, just the smooth circular wires that you put in with kind of a drill, and then you cut them and bend them.
Now, I know this is surgery that she was undergoing, but you were not at this time fixing her hand for purposes of the things that you needed to do. You were just cleaning it?
Cleaning it and stabilizing it.
All right, describe for the jury, please, if you would, what are the primary injuries that Abby suffered from with initial injury January 6th that is visible? And then I'm going to show you soft tissue diagram next after the hard bone diagram.
So you can see at the base of the thumb, there's a fracture at the base of the thumb. Then if you go to the index finger.
And I take it, if you'll let me guide a little bit. Base of the thumb is here.
That's the base of the thumb. You can see there's highly comminuted fractures there. If you move over to the index finger, the base of the metacarpal there's no joint surface even left. It's completely gone with a bone void there as well. And then if we go to the middle finger or the long finger, we can see that there's a large bony defect with highly comminuted fracture.
When you say you lengthen it, what do? You just pull it out and then put wire in?
Yes, sir.
All right, let me switch, if I could, to MV2, please. Should be on your screen. Now, these are the soft tissue injuries?
Yes, sir.
All right, and you tell me where you would like me to go so that you can explain to the jury what is the soft tissue injury. Let me start with the bottom, dorsal external appearance. That's the entry wound of the bullet?
The entry and exit, sir.
And let's move to the left. And I know we just looked at the bones of the thumb. If you could walk the jury from the thumb over to the right and tell us what we're looking at.
So let's start on the index finger. We can see that there was a complete rupture of both of those tendons that extend the finger. And that's where
When you say they're ruptured, tell me what's happened to those tendons.
Oh, I'm sorry. This is looking at the palmar. The picture on the left is looking at the palm. And so that
facing up towards your face.
Looking at it like this. And so you can see that there's complete ruptures of the tendons of the index finger flexor digitorum superficialis.
Could you help us with that in terms that we may understand?
Yeah, I'm sorry.
So this is a hand that's looking straight at my face.
The tendons on the palmar side of your finger allow you to flex the fingers. Each finger has 3 separate tendons. One is called the profundus. There's the superficialis, has 2 slips to it. The profundus goes all the way out to the end of the finger, which flexes the deep part of the finger. The superficialis goes around and comes into here, which bends at the, I guess you'd say, like the first knuckle. We could see that the index finger, the one that goes all the way out to the tip, was 25% lacerated.
Which finger?
The index. And then the flexor digitorum superficialis, 10% lacerated.
All right, now let's go to the far right.
Yes, sir. So this is looking at the hand like this. Looking at the back of your hand like this.
And so her thumb would be on the far right of this right diagram.
Yes, sir.
Tell us what we're looking at.
So the first thing on the top there talks about laceration and contusion of the posterior interosseous nerve. That's a nerve that goes out from your forearm across to the wrist joint, and that's what gives your wrist innervation, or gives you sensation of the wrist.
And what happened to her nerve?
It was transected and contused.
When you say transected, for our
Cut.
purposes,
Cut. Yeah.
Just trying to help make sure we all understand.
Right.
Keep
So,
on moving, right to left.
And then as we go to the right, we see that there's from the small finger to the thumb, as we move from left to right, there's a 75% laceration of the finger that, or the tendon that extends your finger independently. So most of your fingers have a common tendon that helps you extend all your fingers at the same time. the index finger has a separate tendon so that you can point. Like, it's very difficult to point with your fourth or middle finger. It's hard to pull that finger up by itself, but you can do it with your index finger because it's got a separate tendon, which is the extensor indicis
What
proprius.
happened to Abby's tendon?
It was 75% transected, which if you don't do anything with it, tends to rupture.
I keep on going. I take it all these great things or what?
That's bullet fragments.
I keep on going.
So as we go to the right, we see that there's a tear in the thumb joint capsule at the base of the thumb, and
Is that here?
yes, sir, right about there. And then there's a dorsal retinaculum tear. And so if you take your fingers and you go like this, the retinaculum, if you can see the tendons on the back of my hand.
You see the back row there? You need a little bit higher for. And
So the tendons, you can see them kind of on the back of my hand. The retinaculum holds those down tightly here so that they pull the fingers up. If that retinaculum wasn't there, these tendons would do what we call bowstring, and it would try and go from here to here and just lift up and not lift the finger as well. So that retinaculum keeps the tendons in place so that they have a mechanical advantage to extend the fingers. That was torn.
all right, anything else here that needs to be seen?
No, sir.
All right. This is all as of January 6th and 7th of 23, correct?
Yes, sir.
Did you decide and make a plan for surgery?
Yes, sir.
And when were you going to plan to do your first surgery? On the 7th?
No, we did, well, the first surgery on the 7th was
To do the wires.
to stabilize it. We've already talked about. Yes.
Did you decide when you were looking at Abby's injuries to bring in another doctor to assist you with the surgery that you needed to perform?
Yes, sir.
Who was that doctor?
Dr. Scott Tintle.
And could you tell the jury, please, why you brought the doctor in and where did he come from to assist?
So Dr. Scott Tintle was one of my residents at Walter Reed when I was the chairman there. He had went on to do hand surgery, but he and I did a number of the more difficult hand surgeries at Walter Reed. And so when I was looking at this, I was like, this is much more similar to a war injury than it is what I normally see. And having a second set of competent hands in the operating room is very valuable when you're taking on a problem of this magnitude. So I contacted the administration. They said, be happy to let you bring this guy in. We got him credentialed in a few days, and he came down and helped us with the case.
When did you do your first surgery post wiring of her hand?
I'll refer to my notes here.
I'll direct you to January 16th of 23 if that will
Yes,
help you.
that's when we did the next surgery. It was the 16th of January.
MV4, please. And feel free to refer to your notes at any time to any of the issues involving.
Yes, sir.
The first issue, I believe, is a left-hand gunshot volar wound. Tell me what that means.
Volar's the inside, dorsum's the backside. So there's a gunshot wound there.
All right, let's talk about the frame A of the January 16th, 23, part 1.
Yes, sir.
Tell the jury, please, what we're looking at in A.
So oftentimes people will hear about people that get carpal tunnel syndrome from like typing too much or things like that. That's this transverse carpal ligament that you can see being cut in this picture is. Right there, right. You can also get it from traumatic injuries. We knew from the radiographs that there was a large bullet fragment in there, probably irritating the median nerve, so we needed to go get that out.
And so the purpose here is to just remove the bullet fragment.
Remove the bullet fragment, give the median nerve more room to kind of live in a traumatized hand.
All right, let's go up to B, please, and tell the jury what we're looking at here.
So we've just reflected the transverse carpal ligament, and then we remove the bullet fragments in there.
All right, C, please.
So one of the tendons that flexes your finger was lacerated as well, so we repaired that. Flexor did
So where am I looking here? I see that the skin's been pulled back, and then I see a pinching device holding it on the right there.
Right where that arrow points is where we repaired the tendon. You can see the little sutures in there.
Right there.
Yeah.
And so what was the primary purpose other than removing of the bullet fragment of the carpal tunnel area?
Make more room for the median nerve and repair the tendon.
All right, let me move to MV5, please. Tell the ladies and gentlemen of the jury, what are we looking at here? And I take it this is also on January 16th, 2023. We are deeper. Am I on the left-hand side? Am I looking at the top of Abby's hand or the underside of her hand?
So the left picture is looking at the back of the hand.
Back of the hand, I'll use that. Tell us what we're looking at here.
So we see that there's more bullet fragments there that we took out.
Which are all in here?
Those little gray things, yes. And then we see the laceration to the tendon that extends your finger independently.
Right there?
Yep. And the picture on the right shows us repairing.
Before you get there, that in the
Right.
middle there, which I'm messing up my little, I'm going to start again. There you go. Those are all bullet fragments that you pulled out of the hand?
Yes, sir.
All right, tell us what we're looking at here on E.
That's just repairing of the tendon that we saw lacerated on the left.
So it calls it the,
Extensor indicis proprius.
right? What is that specifically? Because I'm not sure I heard those terms.
That's the tendon that by itself is responsible for extending the finger so you can extend the index finger independently of the other fingers.
And what are you doing in this surgery here?
Oh, bringing the ends of the tendon back together and sewing them together.
Does scar tissue normally form in those areas?
Frequently.
And does this scar tissue cause problems and or future problems with someone like Abby?
It causes the inability to flex down all the way because the tendons on the back are scarred in. And on the palmar tendons that were repaired, makes it hard to extend the fingers.
Let me move to MV6, please, and tell me what we're doing here.
So,
And I'm going to go start off at F. We can zero in on F because it's real fast.
so on the back of the hand is where we fixed the index and middle finger metacarpal. This is a picture of fixing the middle finger metacarpal. We put a plate over the area. You can see that there's a large bone void underneath those screws.
So this is a plate, or are those? What is that? Because I see a screw being put in.
That's a metal plate and metal screws that we're putting in there.
And is that to take the place of the bone that was removed by the bullet?
And to hold it stable, yes.
All right, move
to try and help it heal.
Obviously, it's not a final fix. It's to try to get something.
Yes, sir.
Move to the same picture, but go to G, please.
So in the picture in G shows that we've already fixed the index finger metacarpal.
Point to the jury again which one we're talking about so they can see on your hand where we're talking.
This finger right here.
All right, is this the same plate or a different plate?
That's a different plate. There's two plates in there. You see one kind of hiding out under the tendon on the left side of the screen.
Behind there?
That's one that was on the other image. This one right here is for the index finger, and this one had the index finger where you're pointing right there had such bony destruction it took out the whole joint space of the proximal part of the metacarpal. So the trapezium.
And when you use those terms, proximal, could you explain to us what we're talking about on the hand? For us.
Closer to the wrist. It took out the whole joint in there, so we had to do a fusion down to the trapezium.
And when you say
trapezoid.
The bullet just removed the whole bone.
It came out and spit it out across the floor wherever, and it went out when the bullet went in and took bone with it out the backside of the wound.
All right, tell me what we're looking at here.
And this is the thumb where we had to fix the thumb fracture as well.
And again, another plate.
Another plate and screws, yes.
And
we also had to do the joint capsule has gone down there as well, so we had to put in a suture anchor to sew the capsule and ligaments down there.
All right, let me focus you on that for just a second. This is a suture anchor. Where is that going and what is it doing?
It's going down into the capitate, So the tendons that extend your
Kinda
wrist,
help this juror on the far left.
the tendons that come from your arm down to your across your wrist and go into the carpal bones, or those are all the kind of intermediate bones in here that allow you to bring your wrist up. Those had both been completely transected. They're very difficult to sew back into bone, so we put an anchor into the bone and then sew the sutures on the anchor. So if you look at that picture where it says suture anchor, there's some suture there. Down, yep, right there. We take those sutures and tie it into those tendons, so now that when those muscles fire, it brings the wrist up.
Now, in looking at the notes, there appears to be some non-biodegradable drug delivery, antibiotic spacers, I believe, what they are.
Yes,
Could you
sir.
tell the jury, please, what the purpose, what are they? What are antibiotic spacers, and what is your purpose of putting them in the hand?
So, when you have an injury this devastating with bone loss, you're going to have to come back later and do a bone grafting procedure. If you let that just all fill in with scar, it doesn't leave a nice pocket to put the bone graft in. And so we put in this, it's bone cement that people use when they get a total knee or a total hip. We fill it full of antibiotics. Those antibiotics leach out over a several month period of time, so it helps fight infection as well.
So it's basically a time release capsule that's buried into the hand to let out antibiotics
Yes,
to
sir.
stop the infection. Let me go to MV7, please.
And in that we put vancomycin, gentamicin, and tobramycin, three pretty hefty antibiotics to try and
Keep the infection from happening.
keep the infection from occurring.
The risk of an infection to Abby at this point in time is,
It can be devastating.
I believe I am on MV8. 7, I mean. Tell us what we're looking at here. This is, I take it, post-operative, so you finished your surgery. I'm going to start with frame I, please.
So the thumb tendon, there's a sheath that thumb tendon runs in, and that was all damaged, so we took it out of the sheath and just moved it over so it wasn't captured in this damaged sheath.
I take it these are all these are what you've placed in there to help with the bones.
Those are the plates for the bones, yes.
And you've moved soft tissue tendons so that they can be free of the damaged area.
Yes, sir.
What is on the far right?
That's just the same thing.
All right,
So you can see the incision being made in the extensor pollicis longus tendon sheath on the left, and then it being on your left picture where the knife is.
Okay.
You can see that that's taking the sheath that was damaged, opening it up, and then taking the tendon out and moving it over.
And then where is I'm looking at here? Where
It's just a little bit more to the right of the screen than it was on the left.
Gotcha.
You can see the empty sheath behind the tweezers there.
Gotcha.
See that?
Here.
There, go to that right behind the tweezers is the empty sheath.
These
Yep,
tweezers,
right
those
there,
tweezers.
right there, yep.
Right there.
And then the tendon is moved over, so it's not in that damaged sheath.
All right, the next part of that slide, please. So tell me what I don't think we need to see it. Well, let's look at Jay real fast.
So when we talked about the tendons having a tendency to bowstring without that retinaculum, we had to repair the retinaculum there.
And that's what you're doing here.
That's what we're doing there, yes, sir.
All right, let me go to the x-ray on this same slide right here. All right, so this is post-surgery, I believe,
Yes, sir.
January 16th, 2023, and you are looking here at all of the hardware that you put in there.
Yes,
right?
sir.
Tell me what these, I think I know what they are, but I'd rather you tell me, what is all this kind of reddish area here and around there? What are we looking at there?
Those are fractured bones.
And why are they left there in that kind of condition?
Well, if they've got some soft tissue attachments to them, then they've got a chance of healing in. So it's best not to take out things that you think are viable that can help the bone heal.
All right, I take it you continue to operate and work on her, and I believe your next surgery is on March 16th, which would be MV8.
This is still the same. This is March
still on March
16th.
16th?
Yeah, so
All right, so let's talk about A first. What are we looking at here in the upper left?
so it's she had these bone voids in her hand. In order to get bone to fill those gaps, we have to get bone from somewhere. We have to steal from Peter to pay Paul. So we go into the hip where there's good, the bone in the hip has very high amounts of bone growth factors in it. So when we take that type of bone, we get better healing. So that's why we made an incision over the hip, made a little window in that iliac bone, went down and took out a bunch of bone, put it on the back table, and closed the wound.
How do you take the bone off of her left iliac crest?
With chisels and hammers and chisels.
And what are you left with when you do that? Just pieces of...
Well, you leave the soft tissue attached on one side, so it's kind of like a window, and then you bring it back down and sew it into place.
And what are the bone pieces that you've removed? Are they broken bones or are they
No, it's just
What
it's
are they?
the bone marrow from the inside of the pelvis.
All right, let's move to B, please. All right, so I see here, and so that is the antibiotic spacers that you had placed into the earlier surgery?
Yes, sir. Those
And why
are
are you taking them out now in this date?
So we're taking them out now. Now there's a void there in the ends of the bones, and that's where we pack the bone grafting.
All right, let's move to C, please, of that same. So I see this tube here, the blue arrow, and then I see what looks like something you're about to punch
Just
into
a
that.
little-
That is the bone graft from the hip?
Yes, sir.
And tell the jury, please, what do you do with that bone graft in that tube there?
We just pack it in the void between the two ends of the bone.
And how do you keep it from coming out?
Well, that's what putting the antibiotic spacer in it kind of creates a rind around the edges of it, and it makes a nice void to contain the bone graft.
Now, I don't have graphs to show it, but there appeared to be a third surgery in February of 2023 and one on March of 23 that had to do with manipulation. Could you tell the ladies and gentlemen of the jury, what do you do and under what circumstances do you put Abby for those other surgeries?
So when you have bad injuries like this, there's oftentimes a lot of scarring that goes in and around the tendons you've repaired and things. She had kind of hit a plateau with regard to therapy, so we discussed with her and then brought her to the operating room to do what we call manipulation under anesthesia. So we put the patient to sleep so that they can't feel anything, and then push like crazy to get the joints and the tendons and the loosened up so that we can get better range of motion.
And why do you have to do that under general anesthesia?
You can't tolerate that without anesthesia.
So are you worried about damaging the bone repairs that you've done when you're doing that, or are you just focusing on the manipulation so that there's movement of the hand?
It's a balancing act. You know, certainly if you put too much pressure on it, you could bend one of the plates or break the bone and the plate. So it's, you know, after you've done this a number of times, you get to a point where you feel like I just can't go any farther. But we got good manipulation out of her without breaking any bones.
And how many times in February, March, did you put under general anesthesia? Twice for purposes of that manipulation?
We did it once, but the second time we did, we were going in to take out the plates and repair a tendon that had started to lag.
What was your plan and what was Abby's duties for purposes of your treatment between that time, February, March, up until October of 2023? What was she supposed to be doing, and was she doing it as far as
She was aggressively working with occupational therapy to work on range of motion and strengthening.
And what's the difference between what they're doing and what you did under general anesthesia, the manual manipulation?
It's similar. We know that the scar tissue fails by what we call fatigue failure. In other words, if you take a paper clip and bend it once really hard, you're unlikely to break it. But if you sit there and just bend it back and forth, back and forth, back and forth, ultimately that paper clip will break. The scar tissue does the same things. The more you can get them to move, and frequently I'll tell patients with this type of problem, you're reading a book, watching TV, I just want you to move and move and move and move. The more they're moving, the better they have of breaking up that scar tissue.
Now, my memory from looking at the surgery from this March 16th, there was something regarding the tendon itself pulling apart. Do you remember that?
Yes. So
Tell the jury what that means and what it meant for Abby.
So Abby, the tendon that extends your fingers to be able to bring them up, the tendon to the middle finger had done what we call attenuated. In other words, a tendon has got a bunch of collagen fibers that are all hooked together. It had slowly pulled apart and was longer. So when Abby would try and raise all of her fingers, there would be a sag in the middle finger. So what we did is when we went in to take out the plates, we brought that tendon kind of back together, and we call plicate it, trying to bring it back, shorten it up a little bit, and then tie it to some other tendons that have the same function to give her a little better extension of that middle finger.
I take it she's not healed at this point in time, but you are still in the process of getting her better and better as best you could.
So Abby's hand is never going to be a normal hand. It's not going to be like her other side. But we've got it pretty darn close, and a lot of it's attributed to how hard she worked with therapy to do that. I mean, you can do a perfect surgery. If the patient doesn't do any therapy, they're not going to get a good outcome. So she's done a lot of work. I think she's done remarkably well with the number of injuries she's had there, but it's never going to be a normal hand.
I take it you did surgery again in October 2023?
I think that's the one where we took
And that would be MV9?
That's the one where we found the adhesions.
It's on your TV screen, I believe.
Oh, yeah, that's the one where we took out all the plates and did the tendon work for the lagging tendon.
All right, so in A, as I'm looking here, all of these plates have been put aside. And are you in the process of taking out the plate on the right?
Yes, sir.
All right, tell me why you're taking out that plate and what's that leave for purposes for bones?
So, if you've got a plate on a bone, and you can imagine this tendon riding back and forth over top of that bone over time, they can rupture. And there's a lot of stuff in there. Those that were sitting right over the tendon repairs. So it made sense to take out the plates at that point in time, especially when we were going to go ahead and do the plication of the tendon.
All right, let's look at B. Same section, same slide. I take it this is the thumb plate?
Yes, sir.
And are the same issues of concerning the tendons rubbing against the plate over time?
Yes, sir.
Could you tell the jury, please, what is Abby's hand like now 10 months post-surgery once you've removed these plates? What is the condition of her, the hand?
The bones are still healing. They're not healed up all the way, but we have seen union of the middle finger. But she's still got pain with motion. Still a lot of pain is related to the soft tissues.
All right, so tell me, and I think that you can go back to the main slide there. Is this your last surgery with Abby?
Yes, sir.
23?
Yes, sir.
And when you saw her in 23, how would you describe her condition?
So she was having pain at the base of, kind of in this region right here. It was hard to tell whether that was from the index finger bone not healing all the way, where there was no joint and we had to fuse it back to the trapezoid, or whether it was arthritis in the base of the thumb.
And why couldn't scans, x-rays, MRIs, whatever, why couldn't that tell you?
Well, we did do a CT scan. It showed there was a clear non-union there, but these are, a centimeter apart. And it's difficult to tell on physical exam which was which.
Tell the jury, please, what does non-union of that bone mean in that area?
There's fibrous tissue in there, and it's not bone that's healed all the way across the fracture.
And how would that affect Abby in using or trying to use that hand with regard to pain or discomfort when there's a non-union of a joint?
When we tend to have non-unions, it's painful. Moving things with non-unions causes just a tiny bit of motion at that area, and the tissue around the area is what causes the pain. And so anytime you'd use that, you'd feel some pain.
Now, did you decide to do something with regard to this area of her body with regard to a future surgery?
So I would have been happy to just bone graft the non-union. However, I don't do base of the thumb arthritis surgery. That's really a surgery that's done by hand surgeons for arthritic conditions, just like a joint surgeon does knees and hips, a hand surgeon does base of the thumb arthritis. So at that point, I felt that the best thing to do would be to send them to somebody that could treat both of those problems if both of them needed attention.
Once someone went in and opened up the hand, they'd be able to see what the scans may not show and then operate on whether it's arthritis or something else.
Yes, sir.
Did you have a doctor in mind when you did that?
So there's a doctor up in Richmond, Dr. James Stewart, who's widely recognized as he takes on a lot of difficult cases and referrals. And so I called him and said, can you take a look at this and tell me if you think it's the base of the thumb or if it's the index finger non-union? I'm happy to do the index finger non-union, but if it's a base of the thumb arthritis, it's something I'd like to have you take care of.
And as far as you know, he performed that surgery in 25?
Yes, sir.
And you have seen his medical report since that surgery? Do you know if you did?
I think I've seen, so Abby would come back and follow up with us, so I see, but I can't recall whether I actually read his op note or not, because I talked with him. I was like, what'd you do?
Right.
So I knew what he did, but I can't remember if I actually read the op report or not.
Now, you already indicated that Abby's hand is never going to be normal,
yes,
like
sir.
her other hand. First of all, let me ask you whether or not all of your opinions today are stated with a reasonable degree of medical probability?
Yes, sir.
And all of your opinions today relate to her being shot on January 6th of 2023, all
yes,
caused
sir.
by that.
Yes, sir.
Now, when you say that they're permanent, what sorts of problems is Abby going to have, even understanding that she had surgery in 25 for the thumb? What sort of permanent injuries does she have now and will continue to suffer?
She'll certainly never have the exact same range of motion as the other side, never the same mobility. We've fused joints. There's more scar tissue in there than the hand that's not been injured. She'll probably have some component of chronic pain over time.
Does age help or hurt an injury like this?
Being young allows your body to be more resilient than if this had happened to you or I, but certainly a devastating injury is a devastating injury.
What happens when she's 50, 60 years old? What does that do to these injuries?
So she'll be at risk for having some of those tendons rupture as they rub over healed bones and things. Tendons may continue to attenuate. She's had some, color changes to her skin and things based off of probably some of the nerves that were injured in there.
If I could, Your Honor, could I have the doctor just step down and point out to the jury with Abby's hand so the jury can understand where the surgery is and what's left and how it looks now and why does it look so different?
Yeah. Any objection to that?
No objection, Your Honor.
All right. Be careful stepping down. Ms. Douglas, if you wanted to step up, that's fine as well.
The doctor, why don't you do it over here so the jury can see, and I just wanted you to point out what you've done and tell me what the hand.
So first, we look at the back of the hand. Would you want to come over here? So you can see that there's kind of a little divot in the back of the hand. That's where some of the soft tissue is lost. You can see the entrance and the exit wounds are up here. If I ask her to move the hand dorsally, there's going to be tightness in there. If I ask her to flex it, there's going to be tightness in there. You don't see a lot of color change now, maybe a little bit darker here, but as her nerves fire, they can cause blood vessels to expand or contract, and that somewhat gives her those color changes. Although this is better than it was, the ability to extend that middle finger all the way is not perfect yet. You can make it up. And so, you do the other side as well. certainly see that she doesn't have the ability to bring the fingers down all the way. Then you can see on the inside here where we did the surgery there, that's where we do a carpal tunnel surgery and remove that. There's certainly, if you can compare both sides, there's a lot of thickening in there where there's scar tissue. If you bring your fingers and spread them apart, she doesn't have the muscles that spread your fingers apart are called the interosseous muscles. She's not able to fire her interossei don't bring the fingers all the way apart like she has on the other hand.
What about strength?
Oh, so grab both my fingers here. Just grab your hole and squeeze as hard as you can. You know, this side would be considered normal. This is less than half of what I'm feeling on this side, and I think some of the occupational therapy was did some strength testing, but I don't recall exactly what those were.
Sitting here almost 3 years after the shooting, do you believe that she's going to get that range of motion or strength back to any significant degree from where she is today?
Sorry, sir. She may make some slight improvements, but I don't think she's going to make drastic improvements in half her hand be like the other hand at this point.
Doctor, you can take the stand again. I'm not certain that I have left anything out, but I want to ask before I sit. If I could for 1 second, Your Honor. Doctor, please answer any questions the council may have of you. Thank you very much for your time.
Yes, sir.
You want this?
Oh, no. Dr. Anderson, just a few questions for you.
Yes, ma'am.
So your last surgery was in October of 2023.
Yes, ma'am.
And are you aware that a few months later, Ms. Werner started cosmetology school?
Yeah, I didn't know how long after that she started it, but I know that one of my appointments we talked about that.
And are you aware that she completed cosmetology school from January 2024 to January 2025?
I did not know that she completed or graduated, but I knew she was in it, and
You had no objection to her going to cosmetology school?
No, ma'am.
And did you, or were you aware that she has become a licensed cosmetologist in the Commonwealth of Virginia?
I did not know that she's become a licensed cosmetologist, but congratulations to her.
Congratulations. And Dr. Anderson, do you, in your course of treating Ms. Werner, do you recall a time where she contacted you and asked you to backtrack and write work notes for the past 2 years?
Yes.
Tell me about that.
This happens all the time in clinic when people have had some injury and now they're looking to get back into doing things, and there's, maybe we didn't do that in the past, and at some point in time when she's not working and we don't give them a work note, we have to go back and amend work notes, not infrequently.
Okay. So you had not done work notes in real time for Ms. Werner for the past 2 years?
Yeah, I don't recall, quite frankly. I'd have to go through my notes and say whether or not we did or we didn't. It's not something that I usually do. It's something that when you take care of an injury like this, there's a large number of people that are helping take care of things. We have medical assistants in the clinic that frequently do that stuff for us, and then I'll sign it. But I oftentimes, if we miss it, we have to go back and do it later.
Just asking you, Dr. Anderson, do you recall backtracking a work note?
Yes.
You backtracked a work note?
I know we had to do work notes to make up for time that we didn't have work notes previously.
Thank you, Your Honor. Thank you, Dr. Anderson.
Yes, ma'am.
I promoted you to a judge.
I'm not sure that's a promotion.
I want to follow up. After you do these different surgeries that we've talked about, what do you do with her hand? Is it wrapped? Is it a cast? What is the condition when she leaves the OR or the hospital?
So usually we put it in with dressings and a splint, and that splint needs to come off fairly quickly, because usually if you left something in a splint for 6 weeks, it's just going to get stiff again. So like when we're doing manipulations under anesthesia and we're trying to get the tendons to move and things, we'll put it into a splint just to let the soft tissues heal, let the wounds heal, and then start range of motion, usually around 2 weeks.
Did you want her to be careful about the use or damage to that hand post-surgery?
Yes, sir.
I have no further questions of this doctor.
Any follow-up based on that?
No, Your Honor.
Dr. Anderson, thank you very much. I appreciate your time.
Is he free to go?
He is free to go.
All right, you are free to go. You're excused from court. Just please don't, because the case is still ongoing, don't talk to anyone about it, okay? All right, thank you, doctor. All right. We are ready for the next witness?
Yes, I'm ready for Dr. Stewart. Jeb Stewart. Witness has not been sworn in.
I'll get you stand right here, face my clerk, raise your right hand.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. This way.
Sit over here, please.
Watch your step, steady.
Good afternoon, Doctor. Could you tell the jury your full name, please?
James Yule Brown Stewart.
And are you an orthopedic surgeon?
Yes.
Dr. Anderson just testified and says you take on all the hard cases.
Challenging.
Could you tell the jury, please, a little bit about your medical education background?
I went to medical school in Norfolk, Eastern Virginia, and Army scholarship, and trained as a surgery intern in El Paso, Texas, at William Beaumont Army Medical Center, and did my orthopedic surgery residency at Walter Reed Army Medical Center, and subsequent hand surgery fellowship at Walter Reed, and served 4 more years in the Army. Retired in 2021 and came to Richmond, Virginia.
How long you've been doing orthopedic surgery?
Since a residency, close to 30 years.
Your Honor, without going through more, I tender the doctor as a specialist orthopedic surgeon.
Any objection?
No objection, Your
All
Honor.
right, thank you. He's qualified as an expert in orthopedic surgery. Is that correct?
Dr. Stewart, I'm going to try to narrow your testimony because Dr. Anderson took us all the way up to when he referred Abby to you.
Yes.
And I take it that you took her under your care at the advice and recommendation of Dr. Anderson because of a particular problem with her thumb?
Yes.
All right, I'm going to show you, first of all, MB10, which is a medical illustration, which I believe I had sent to you, and ask you if this would help for you to describe to the jury what you did.
Yes.
All right. Your Honor, permission to publish MB10?
Any objection?
No objection.
All right, once again, demonstrative.
Yes, Your Honor.
All right.
It's on your screen, Doctor, and if I can point, and I'm going to look at slide A first. And first of all, as we're looking at A, tell the jury what you found when you went in initially to look at Abby Werner's hand. I think if you had to open her up besides
Sure.
scans.
Well, what I expected, which was an unhealed bone in her left hand with a defect.
And what kind of defect?
We call it a non-union, where the bone did not heal.
Now, Dr. Anderson had indicated that she was having some pain in that area of the hand, and he wasn't certain whether it was arthritis or it was a non-union or what, which is
Correct.
What is it that you found, and what would you describe the reason that she was having pain in that part of her hand?
My initial evaluation, I was more impressed with the pain in her thumb joint, which is just underneath that device with the bone graft, even though she had movement of the non-union in her left hand. And I tried a cortisone injection to the joint right next to that area to see how she would do for both therapeutic and diagnostic reasons.
And how did that shot help for her?
She came and saw me a few months later and said it helped for about a week or two and had moderate relief, but at that time also complaints and exam findings were more consistent with a symptomatic non-union or the problem there at that metacarpal in her left hand.
Do you know when you first started seeing Abby? Was that the beginning of 25, or when was it?
That was December of 2024.
And is that
almost
when
2 years from the time of injury?
Gotcha. Is that when Dr. Anderson had referred her to you?
Yes.
All right, so I take it you attempted to perform surgery to try to relieve this pain? Is that what we're looking at in April 14th of 25?
This illustration illustrates the surgery that I recommended, which is a repair of the non-union using structural bone graft from her pelvis.
All right, so let's go to B, please. Dr. Anderson had indicated that he had taken a pelvis bone.
Yes.
Did you have to do the same thing?
Yes, from her opposite side.
So you went into the iliac crest of the other side?
Correct.
He described moving or chipping away the bone, putting it aside.
Object to the leaving.
Go ahead and tell us what you did on the iliac crest of the opposite side. I apologize.
Objection is sustained. Now you can answer.
I'm going to rephrase it. You tell us what you did with the iliac crest of the right side.
So this type of problem requires good bone graft, and it's typically from the patient. We call it autogenous. And the iliac crest has probably the highest quality bone graft. And you basically remove a section of bone from the iliac crest or pelvis. And her original bone graft donor site was on the left, so I went on her right side to get that.
And where did you place it?
I placed the bone graft after cleaning up the non-union site in the space, and it measured about 1.5 centimeters or so in length to fill the defect.
And when you say it measured, is that the gap size for the
gap
non-union?
size, once it was cleaned up, the non-union and the devitalized tissue, yes.
All right, so what are you doing here in B of MV10?
You can see the bone graft, that little trapezoidal area of bone at the base of the metacarpal, and then the plate and screws.
Is that right there?
Correct. And the plate and screws are being used to stabilize the bone to allow it to heal.
Now, if my understanding is correct from earlier testimony, Dr. Anderson had a bone graft, a piece of like this before?
I think it was mostly cancellous, but I'd have to go back and look at his operative report, which was from the iliac crest.
And what is a cancellous?
Well, you have two types of bone, and one is cortical, which is the hard bone that we all see, and then inside that bone you have cancellous bone, which is in the medullary canal.
And so
it's
what was
spongy.
And what was the purpose of this plate here?
To stabilize this structural corticocancellous bone graft inside the defect to allow that bone to heal.
Back up to the full picture of 10, MV10. All right, looking at the far right, the post-operative surgery. So you did surgery when on April 14th, 25?
Yes. Yes.
And if I'm not mistaken, the X-ray that we're looking at the far right is dated when?
What the objection to leading?
I'm asking when is the date of the X-ray on the right side?
So sustained is the first part of the question. Now the second part. Go ahead.
I'll rephrase it, Your Honor. I don't want to. When is the X-ray taken on the right side of this diagram?
Well, according to the diagram, 5 August 2025.
So that's just a couple of months ago?
Correct.
Tell us what we're looking at and what do we see?
What you see is the plate in place and the bone graft, and at that visit, I felt as though there was some evidence of early consolidation or healing. These can take upwards of 6 to 12 months to be completely consolidated.
As we sit here now in October of 25, is that plate still in Abby's hand?
It is.
Do you believe, first of all, do you have any idea as we sit here whether you'll be able to take out that plate and when?
Yes, and I have spoken to her and will probably recommend taking that out within 6 to 8 months. She still has a fair amount of pain over that area, which I think is related to the plate and the screws. So probably within a couple of 3 months, we'll get a CT scan to assess for complete consolidation and then subsequently plan on removing the implants because they are so close to the skin.
Do you believe that Abigail Werner's injuries in her hand as a result of this shooting on January 6th are permanent?
Yes.
Do you believe that your testimony and your opinions today are based on a reasonable medical probability?
Yes.
1 second, John. I have no further questions. I appreciate you giving us your time.
Thank you. Any cross-examination?
Just a few questions. Dr. Stewart, are you aware that during the course of your treatment of Ms. Werner that she's completed a one-year cosmetology program?
Yes.
And you know she's a licensed cosmetologist in the state of Virginia?
Yes, it's reflected in my notes.
And you don't have any objection to that, Your Honor?
No.
You don't? Thank you.
Your Honor, minor issue beforehand.
All right.
Your Honor, there was a colloquy before we, I think, went on recess earlier about how Your Honor had previously ruled on the motion regarding collateral source, the GoFundMe, shirt fundraiser, that kind of stuff. I'm looking at the transcript, and there's, I think, a disagreement of ESTA's scope, and we're raising an issue that we think is distinct from that, but is related to legal grounds.
All right, let me get my notes.
Yes, Your Honor.
That was, I believe, plaintiff's 5 text messages and gratuitous contributions.
Correct, Your Honor.
That was the 5th motion we took up that day. And for the record, that was October the 16th of this year. All right, go ahead and tell me the issue here.
Yes, Your Honor. And for context, if it helps, page 153 of that court transcript has Your Honor's ruling, which is I'm going to deny the motion to exclude the question about whether someone did or didn't contribute, but I'm going to grant it as to any amount. So what we're dealing with now is the next witness is Ms. Werner's sister. And what I now learn from defense counsel, which is a different evidentiary issue, the question isn't did you or didn't you contribute, which Your Honor has already ruled upon. The question is, did you create a GoFundMe page? Did you create a shirt fundraiser page? Did you create these things? Our concern here is, of course, the sister, in the context of someone who is not related to Ms. Werner, has inherent bias baked into the relationship of the individual. And there is going to be testimony as it relates to things that she did to benefit the plaintiff as a result of this injury, whether it's shirt fundraisers or GoFundMes or whatever it might be. If we venture into the area of talking more detail about what was the shirt fundraiser, how much were people charging for the shirt fundraiser, things of that nature, we're getting very close to this collateral source issue.
Right, yeah, I'm not allowing that. I agree. We're not talking about money. I've made that clear. You can ask her. Yeah, I mean, I'm going to overrule your objection as to asking her, did she create these things? But that's it.
Your Honor, that was my plan, and I looked at the transcript from before, and I very clearly said I would like to ask this witness, did you create a GoFundMe, and did you create a T-shirt site? And are those still active? That's it.
Okay.
No amounts.
All right, and
no
I think,
amounts, the cost of the T-shirt, anything.
all right, and once again, I have no problem with you bringing this up ahead of time. I appreciate it. I understand your objections to that, and those are preserved from the October 16th hearing. But as long as we're clear on what we can and can't ask, and I think we are now, then I think, are we otherwise ready to proceed?
Yes, sir.
All right, anything else you wanted to put on the record about that? Okay. All right, call your next witness. No, we'll bring them in. We're not going to forget them.
Nine jurors in the box.
And your next witness.
Ms. Werner.
All right, come on up, Ms. Werner.
Come forward. Let me get you stand right here. Face the clerk. Raise your right hand.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do.
All right. Sit up. Watch your steps. That's enough. Take your time.
May it please the court. Good afternoon.
Good afternoon.
Can you go ahead and introduce yourself to the jury?
Hi, I'm Hannah Werner. I'm Abby's twin sister.
And Hannah, I am going to show you a roadmap that I promised you. And if we can publish this to the jury. Oh, it's an old one. It's not the right one. Always technical difficulties. Well, that's up. How are you today?
I'm doing okay. How are you?
Good. You a little nervous?
Yeah.
I know that you were planning to testify tomorrow and made it over here today, so thank you.
Yeah, of course.
So, we've got a roadmap in front of you now, and this is just the 3 buckets of stuff we're going to talk about, okay?
Yeah.
And I drew 2 roads because the 2 of you kind of twinned together and you started. And then we're going to talk about growing together. And then we're going to talk about life today, okay?
Yeah.
Ready?
Mm-hmm.
All right. So, natural question for twins. Who was first? Who was second? I heard Abby's the middle child, so tell us about that.
Yeah, Abby is 8 minutes older. We do like to joke that, well, I joke it was the best 8 minutes ever, just stretching out before I was pulled out into this world. So she is 8 minutes older, but I am a couple inches taller.
And that's, you're balancing
Yeah.
between the 2 of that.
Yeah.
And growing up, were you the type of twins that dressed the same? Mom put you in the same clothes to school, or how did you guys handle that?
I can confirm there are pictures of us when we're like toddlers dressing similar. However, when we grew up, I really wanted to dress alike. I don't think I understood that there's a difference between identical and fraternal twins. She did not want to dress the same as me.
And as you were growing older, you also had an older brother.
Mm-hmm.
And your older brother, as we learned, was 16 months older than you all.
Yeah.
Your Honor, I just object to the relevance of this.
All right, can we move on?
Sure, Judge.
All right, thank you.
And during those times growing up early in life, did the 3 of you grow a bond together where you could understand who Abby is as a person and how she changed through the years?
Yeah, I mean, we've built a lifetime of memories together. We're very close. I think she's even more than my best friend. She's my sister.
And as you all grew older through middle school and high school, tell me about your desire to stay close to Abby and Abby's desire to make a name for herself.
I think I always wanted to be more like Abby. If she did something, I wanted to do it. But yeah, as we got older, you kind of want to figure out who you are. So while we are very similar, I think we're different as well.
And when it came time to choose where to go to college, had you all gone to school together up until that point in time?
Yes.
And then what was the decision that you all made at the time of college?
I could not go to the same college as her.
And that was her instruction?
Yes.
And where did Abby decide to go?
James Madison, and she loved it there.
And where did you go?
Christopher Newport.
And did you have things in common in terms of sporting teams and things that you liked?
Your Honor, again, object to the relevance of
All right, what is the relevance?
Your Honor, ultimately, we're asking this jury to understand the difference between Abigail Werner before and after January 6th. In order to illustrate how she, if at all, has changed, we have to first get an understanding of the foundation of the witness to be able to demonstrate her knowledge of the individual, describe what life was like beforehand, and then differentiate those experiences after the fact.
All right, overruled. You may proceed.
Thank you, Your Honor. So, we can go to what's been pre-marked as 90C. And we'll just show that to the counsel. It's already been shown to counsel before, but just in case, Your Honor. You see that up on the screen?
Yeah.
All right. That's a picture of your sister?
Yeah. We were an Orioles family growing up. We went to games, we watched them together, and that's definitely my shirt. Yeah, she's sitting in her classroom. I helped her put some of those things up. She's very particular about the way that she wanted her decorations. Yeah.
Permission to publish, Your Honor? And I'd move it into evidence.
No objection, Your Honor.
That's your jersey, huh?
Yeah.
So, as you all were getting older and she started teaching, she moved back to town, right? Back to the peninsula.
Yeah.
And did you two live together?
Yeah, we did. While she was finishing up James Madison, I was in Florida, but moved back, and we were both teaching at the same time, living together. Yes.
And when you all were teaching, obviously out at work, you come back home at the end of the day.
Yeah.
Would you guys spend time together in the living room?
Yeah, every single evening. So I was a high school English teacher. She was an elementary school teacher, and she had like mountains of paperwork. She would hook up to the printer in our living room and print things for lessons the next day. And I just remember thinking, she's so dedicated, and I just never brought work home. That's just, how the two of us were different. Every single evening, she would be on her laptop prepping for the next day. She went to work early. She came back after hours. Yeah, that was our life.
And when she wasn't sitting on the chair in the living room with the printer, what did Abby like to do?
Hang out with friends, go out shopping. She could never sit still. She always wanted to get out and do things.
Was she a book by the fire kind of person on the weekends?
That's me.
And growing up, was that always how she was?
Mm-hmm.
Did you all go to amusement parks like Busch Gardens and things like that as a kid?
Yeah, and Abby was always the one to stay behind. Always kind of timid. While my brother and I would, go on the roller coasters, she was fine with the teacups. If we were going to Virginia Beach, my brother and I would go into the water and she would stay behind, always observant and timid and watching, but always present.
And in your interactions with Abby, as twins or just as sisters, did you two grow to develop an unspoken bond?
Yeah.
Tell us about that.
We can look at each other and know exactly what the other person is thinking. She's agreeing right now, I can tell you that. Yeah, I mean, like I said, when you've been with somebody your entire life, I've never been in this world without her.
Your Honor, again, I'm going to object. We're getting far afield of anything that's relevant. Ms. Werner's feelings are not at issue here. It's about her sister.
I disagree, Your Honor. I think ultimately we're putting on a case tomorrow about an evaluation, a psychiatric evaluation, and to lay the foundation of the differences and the changes in her demeanor, who she is, how she shows up in this world. Who better than the person who's lived with her their entire life, but 8 minutes.
Right. Let's move it along to those topics.
Yes, Judge.
Right.
So, when you spend time with Abby and before this time, I'm going to show you a video, if you can. This is 90D.
Which number is it?
90D as in dog. Yes, please. See that picture of her? Or video, I should say?
Yeah.
What does that remind you of your sister before January 6, 2023?
Full of light and spark and just so outgoing and just silly.
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 I'm going to change gears and talk about after January 6th.
Okay.
You said that was silly, full of light. Can you tell us about that light in Abby today?
It's still there. It is very dimmed.
And it's dimmed like what?
She's just not the person that she was. I feel like she's kind of lost her sense of direction in a way. She doesn't want to go out anymore. I don't talk to her as much as we used to. We talked about the unspoken twin language, and I don't know what she's thinking all the time. And yeah, I think that she had a lot to be excited about, and she doesn't anymore. And so that light has kind of dimmed.
And are there times since January 6th where you looked at your sister and you felt like you can't read?
Yeah. She doesn't want to talk about things. She doesn't share them with us.
And in your impression of your sister, is she a people pleaser?
Yeah. She wants everyone to be happy, and doesn't worry about herself, but worries about everyone else.
And when you say she's keeping stuff to herself, tell me what that looks like when you see it in the real world.
Just shutting down, becoming more reclusive. Yeah, it's like a wall is put up between her and the rest of the world.
And before January 6, 2023, did you ever feel like that wall was ever between you and your sister?
No.
Do you feel like there is a wall, however tall it might be, between you and her now?
Yeah, we're working on it, but it's there.
You said earlier that she's sort of reclusive.
Mm-hmm.
And we talked before about sort of her demeanor to not be the person to grab a book and sit by the fire.
Yeah.
How has that changed since January 6th?
She doesn't leave the house. It's very hard to get her to go out and do things, and if she does, someone has to be with her. She's really afraid of being alone.
And when she's out and about, because she is sometimes, right?
Yeah.
And you see her, do you see that same light, that same color in Abby that you used to see?
No.
Can you tell us what you do see?
Someone who is scared but trying to be strong for other people.
Is that what you see today?
Yeah.
Thank you, Hannah. Those are all the questions I have.
All right.
Just a few questions.
Cross-examination.
You've told the jury that your sister's been more reclusive and withdrawn from the community.
Yes.
You have put your sister out in the community through fundraising websites, haven't you?
Yes.
You created a GoFundMe page.
I did.
And it has Abby's picture on it, correct?
Yes.
It puts her story out in
Yes.
the internet.
That's correct.
And you also have a website to sell T-shirts.
That's correct.
And again, you put your sister's story out in the universe and make her available.
That is correct. It was not without her permission, if that's...
So she allowed that. And you talk about that your sister doesn't want to go anywhere. Have you given your sister any gifts of concert tickets?
I
since
have.
that? And where was that?
I drained my bank account to take her to Taylor Swift.
So she was able to go to Taylor Swift?
Yes.
And
it was not without its own challenges.
That's a pretty large crowd?
It was.
Where was it?
Philadelphia.
The Eras Tour in Philadelphia?
That's correct.
And your sister was able to go do that?
Like I said, yes, but it was not without its challenges.
Thank you. No further questions.
Thank you.
Any follow-up?
Yeah, Your Honor.
All right. Is she excused?
She is, and similar to Mrs. Werner, we'd ask that she be permitted to remain in the courtroom if she wished.
Is she under your subpoena, Ms. Douglas, at all?
She is not.
Okay. All right. Then you are excused from court. However, you may stay in courtroom to listen. All right. Thank you. All right. Are you moving 96 and 90D into evidence?
It was 90C and 90D, and yes, Your Honor.
All right. Any objection to those two? All right. Those are admitted. All right.
No other witnesses, early release again.
All right.
We were ahead of schedule, Your Honor. We have 2 witnesses tomorrow morning on the plaintiff's side that we intend to call.
All right. And then is that who are you planning to rest after that?
Yes, Your Honor.
Okay. All right. And then will the defense have witnesses ready to proceed in the afternoon tomorrow?
Judge, we're attempting to coordinate some potential witnesses who might be available. That's in the works, and we'll try to provide an update as quickly as possible to opposing counsel.
Thank you very much. I'd like to get as much done as we can because I do want to try to have an early release on Friday for Halloween, get everyone home to either their kids or handing out candy.
Your Honor, I don't think that'll be an issue at all because we certainly won't be able to fulfill the day on Friday, and I wanted the court's indulgence. We talked about that yesterday.
Okay, very good. I'm not going to recess court. I am going to excuse the jury, however. All right, ladies and gentlemen of the jury, we're going to take our break for the day, and we will start fresh tomorrow morning at 9 a.m. Again. So get a good night's rest, and as you've heard me 3 times already, I guess, but I will read it again. Ladies and gentlemen of the jury, we are recessing now for our evening. I ask that you be back in my courtroom back upstairs at the main building at 9 a.m. During this break or recess in this course of this trial, you are not to begin discussion of any aspects of this case. Upon your return, you are requested to go immediately back to our courtroom and not loiter in the halls. You are not to engage in any conversation with any of the parties, the witnesses, the attorneys, or the spectators. You are not to go to the scene of the case or undertake any independent investigation using any means whatsoever, radio, television, internet. No one should approach you and discuss this matter, and you should not remain within hearing distance of anyone discussing it. Of course, that includes viewing newspapers or television or listening to the radio. You must also leave your notepads and any notes you have taken with my sheriff. Once again, no one will look at them and they will be destroyed at the end of the trial. If you are approached by anyone concerning your jury service during the course of this trial, make that fact known to me and my bailiff. I will see you at 9 a.m. tomorrow. Have a good evening.
Please bring your notebook.
All right, everyone may be seated. In anticipation of the defense experts being called on Monday, is that where?
It is, Your Honor.
Okay. Were any of the reports prepared by those experts? Were any reports prepared by your experts?
Yes, actually, Dr. Hagan does have a report.
Okay.
But there's no motion in limine related to his testimony.
Okay. And that was disclosed to plaintiff's counsel?
Of course, Your Honor.
Okay. Was it filed in any manner with the court at all?
No.
Okay.
Discovery was not. It was because it's discovery, it's not filed with the court.
Okay, I just wanted to find out. All right, very well. Then we will be in recess until 9 a.m. tomorrow morning.
Your Honor, may I correct that? It may have been filed in response to the motion in limine. Would you like me to check and determine?
I mean, if it was filed, we'll look for it. I just didn't know where we should look for it. If it was, it would be in your motion in lim?
Yes, Your Honor. Because it was Dr. Hagan, the forensic psychologist, and he did not, was not subject to a motion in limine by the plaintiff, I may not have included it.
Right.
But I certainly included the designation. I'm not sure. I don't think there's any objection to Dr. Hagan's testimony. I think the only issue left will be our forensic psychiatrist, and there's some objection, I think, to that.
All right, I guess I would just ask you to provide me any evidence so I can work on it this weekend that you think you'll be presenting in support of the motions.
Okay.
Anything that'll help me.
Your Honor, I just handed opposing counsel. It's just a bound version of all of the expert reports and CVs from defense. It's an extra copy of ours. If it's easy for the court and they're agreeable, we're happy to provide that to the court for Your Honor's ease.
Did you want to look through them, Ms. Douglas? And
I will
then...
look through it, and I greatly appreciate it.
Okay.
I'm happy to give it to the court.
All right, great. If there's no objection to that, I'll let you have a minute to look through it, and then you can hand it to Deputy Hopkins, and I'll take it, not to be marked as anything, but just for my knowledge and so I can work on it.
Yes, Your Honor.
Okay. All right, anything else to take up before we break?
No, Your Honor.
All right, court is in recess until 9 a.m. tomorrow.
Please.